Is the university closed for the year?
No, not yet. I'm not with the university anymore. They left Rhodes at the end of September. But
really?
yeah, so I'm closed as far as the university is concerned. Yeah, yes, I took early retirement at the end of September. Decided it's time to rather just work for myself. I'm not with the university anymore. They left Rhodes.
Can't finish.
Oh, got an echo here. Now I'm hearing
Sorry,
everything again.
I had
I thought you were a ventriloquist.
Yeah. I thought there was somebody else who sounded just like me.
Yeah. So now what are you doing? Gone fishing?
I wish. I'm doing this. I'm doing training. Yeah, training and yeah. Well, this year just focusing on seeing through all the webinars and so on to the end of the year. The next year I'll still do some academic work, but not full time for the university. Just yeah, sort of on a sort of part-time basis, and then focus on this tax training and consulting. Go back into tax consulting again. Because, you know, I've always had to stay clear of opinions and getting involved in tech in advisory work because of the commitments at the university. So I decided now I'm rather going to focus on that side of things. Yeah. Yeah. So it's good. Keeps me busy. Yeah.
Yeah.
So are we live now? Are we actually, or is it
yes,
just?
Yes, we are. We have about 60 people so far in.
Okay.
61.
So you'll tell me when to start, hey?
Well, yeah, we have.
Stan, are you going to do an intro? Yeah, yeah.
Yes, of course. Although you don't need an intro, everybody knows you.
Give it another, I think, 2-3 minutes. But
okay.
I see traditionally people start at 2 minutes past. I don't know what that story is about.
Can people?
Well, they're
can
lucky
people
we don't have a whole long. At least these don't have a whole long advertising thing before we get started. Just us, Dan, doing an advertising little clip here.
Yeah, I just want to just check it. Can people see? I have put links to the notes in the chat box. I posted it earlier, but I don't know if it's still available or can people see it?
I can't see it now.
I can't see it.
Okay, I'm going to link it again. I'll just post it now again.
There we go.
All right, yeah. Wasn't sure if it would show from an earlier one or not, but it's there. I'll post it again in 10 minutes for those who joined late.
So just the notes are just a click away.
Yeah.
Apparently the sound is clear. It's an almost clear day outside.
It is indeed.
All right. 67 up in now.
So now that you've left the university, do you retain the title of professor?
Yes, hopefully. Yeah, that's all still being sorted out because it is quite an official sort of process. Yeah, but yeah. Otherwise, I'll go to doctor because with the PhD, I should actually call myself doctor. But I don't like calling myself doctor because people might then think I can administer first aid and do stuff like that when I really can't.
Well, you probably would do well in the tax arena if you could administer first aid with all the frustrations.
Yeah. Yeah.
So now I'm always very hesitant to
call myself doctor.
Nobody from SARS is listening. Can be professor, doctor.
Right. Yeah. Yeah. Or doctor, professor. So it's alphabetical. I'm not sure. Anyway, yeah, that's a problem we'll worry about for next year. Yeah. Yeah. Okay. Are we just about ready? How are we going there? 74.
We're at 71. I think we're pretty much 3/4 of the way there. So I think we can always start, and then those who join late they can either catch up on the recording or they'll just follow in.
Okay, so welcome, I guess, to the last Zoom meeting for 2020. Everything will be cancelled from the end of the year. COVID will be gone, and we'll be starting afresh. So hopefully in 2021 is going to be a great year. We're privileged yet again to have Professor Dr. Jackie Arendse, recently retired from Rose University and available for consultation and training. So if you need any help, you know where to go. She's just a click away. And we're in for a taxing afternoon, another taxing afternoon. And Prof, the floor is yours. I'm going to go back to eating my lunch.
All righty. Well, thanks very much. Let me just get onto my screen. And okay, hold on. Oh, hold on a sec. So yeah, not just yet. Yeah, so just to say welcome to everybody. I'll get onto the screen in a moment. Sorry, that I just wanted to check that I could change over because we had Danny's screen. And then I'll go onto my screen in a moment. Okay, but welcome to everybody, and it is great to see you here. And even though you can see me, but I can't see you, but I can see all your names on the screen, so welcome. And welcome to our year-end tax update. I'm going to run this. I have pre-recorded it just to make sure that there's no technical issues along the way. So I'm going to switch over to share my screen, and then I'm going to run the update. I'll be here dealing with any questions that might arise. If you do have any questions, pop them into the chat box, and I can deal with them when we take a break. We'll take a break at 2:30 for 15 minutes. And then we'll go into the second session through until 4 o'clock. Okay, so any questions, pop them in there and we will deal with them either just after the break or just before the end. There's some time for Q&A as well. Okay, so I hope you enjoy this. Thanks. Just to check that it is sharing my screen. Let me just check, Danny.
Did you set yourself to optimize for video?
Yeah,
when sharing.
So that's great. Okay, yeah. All right. So let's go. So in today's
Jackie? I would say pause your screening, your sharing, and then once you opened your video, then start sharing again with that, I would think.
So is it not coming through? Should I stop sharing?
Stop it, and then make sure when you click it that you optimize for video.
Yes. Okay. Alrighty. Let's try that again. And I just want to stop it and then just check that it is. Ugh. I was hoping it had, right, let me just see here. So it is sharing my, Danny, I think it's still got your screen. Let me just see.
I'm not sharing, so it's.
Because I'm seeing your CPD on the screen.
I haven't shared anything.
Let's try this again. Are you seeing my screen now?
I'm seeing your screen, but just with your files.
Let's try something else here. Okay, are you seeing that now? Is the shared screen coming through, or still just the files? It's very strange. Just the files.
When you share your screen, do you share? Wait, something's happening now.
Now, are you seeing it now?
Ooh, I'm just seeing a narrow line.
And let's just try this. Now, Sorry about this. I thought it was all ready to go. Are you seeing my slides now? It says 2020 year-end update.
I'm not. Stan, are you seeing anything?
Let me, are you, so even now, when I go onto my PowerPoint presentation, are you not seeing anything?
No, it's just got a black, it's just a narrow, I can just see the top.
See, okay, let's try something else. Let's go try something else here. Sorry, everybody, apologies for this delay. Let's close that. Okay, I'm going to just go in and just do it then from the PowerPoint. Let's try this. Gosh, how strange. Okay, now are you seeing? Okay, let's just try, go back here. Okay, are you seeing my slides now?
Yeah, I'm not seeing your slides.
Yeah, okay, that's great. Then I'm just going to present from here. That's fine. All right, no worries. We'll just go from here. Let me just maximize the slides and we'll just run it from here. That's fine. And duplicate. Right. Are you seeing it all okay?
Now it's working, yeah.
Okay, great. All righty, so that's fine. We'll just present from the slides. Okay, so what I'm going to be covering this afternoon is looking at the 2020 amendment bills and the Disaster Management Tax Relief Act, which, as you can see, has now been promulgated. I'm not going to go into all the amendments in the Disaster Management Tax Relief Act. There's just a few things that I wanted to chat about, things that are sort of carryover issues. So we'll talk about that. And that will be towards the end of the presentation. During the course of the year, when we've done our other updates, we've done all the tax cases and all that sort of thing. So there's nothing else to cover on that side. So we're just going to focus on the legislation today. All right, so the 2020 amendment bills, these were obviously followed on from the budget speech that was presented at the end of February 2020. And of course, at that stage, we didn't know COVID was going to hit, right? If we can sort of think back to that era, it seems like a lifetime ago. But these bills obviously then contained the tax amendments that were announced in the budget speech. And we had the draft bills released for public comment on the 31st of July. So anybody who wanted to submit a comment could do so up until the end of August. Basically, those comments had to be submitted in writing and so on. SARS and National Treasury then on the 19th of August briefed the Standing Committee on Finance, which is the Parliamentary Oversight Committee, dealing with fiscal policy and tax legislation. So they received a bit of a briefing on the bills, what was in the bills, bearing in mind that they are all politicians and not tax specialists. And then the stakeholders who wanted to present oral submissions were able to do so on the 7th of October. Okay, so just to pause there, although these bills contain pretty much all of the tax amendments that were announced in the budget speech, the two that haven't carried through are the limitation on interest deduction and the limitation on set-off of assessed losses. Those haven't appeared in the legislation yet, so that presumably will carry over to next year. Okay, so then once the stakeholders had presented their submissions, 13th of October, we then had the feedback from SARS and National Treasury, and it's worth noting that they give feedback in one way or another on every submission that is made. So, I mean, you might find that there's multiple people saying the same thing, so they don't necessarily respond to A, B, and C, but they do respond to all the submissions that are made. And they then gave their feedback as to what submissions they were going to take on board, what submissions they rejected, and what submissions they noted, but weren't necessarily going to amend the legislation. So that's always a useful document because it kind of tells us where things are going from the draft bill through to the final bill. And then we had the final bills tabled when the Minister of Finance presented his medium-term budget speech on the 28th of October. I think everyone was too focused on the state of the fiscus and the economy to really notice that the bills had been tabled, but nonetheless, they had indeed been tabled. So they are now going through the parliamentary process, National Council of Provinces, and then ultimately through into the in tray of the President to be signed into legislation. And we expect that to happen, well, who knows, anyway, maybe early December before he goes on leave, or January when he gets back from his leave. Okay, so it'll be sometime December, January. We would expect that these bills would then be promulgated into acts. Okay, so the main amendments that are contained in these bills, there was discussion around further COVID relief, but that hasn't actually translated into amendments at this stage, although the message from National Treasury has been that they might still consider later in the legislative process. This would have to now be next year, of course, because I mean, this year's all but done and dusted. But what has come through, and this was only in the final bill, was this amendment to the foreign employment income exemption dealing with the 183-day requirement. I'm going to talk about all these in more detail as we go along, so just highlighting it now. And then also amendments around the employer-provided bursaries, the exemption available for employer-provided bursaries, and then 3-year limitation before one can withdraw your funds from preservation funds and retirement annuity funds if you immigrate. And then preference share structures coming into Section 7C, the deemed donation provision. Then Section 8, a bit of a kind of an unexpected amendment coming through there, but obviously there have been some practical issues around reimbursements for employees who incur expenditure when they travel away from home just for part of a day. So they're clarifying the tax treatment there and slightly changing the wording to just make it more practical. And then some amendments to the doubtful debt allowance. Then 3 amendments to the corporate reorganization rules, some amendments dealing with loop structures, and then paragraph 80 of the 8th schedule dealing with the distribution of capital gains from trust to beneficiary. Some VAT amendments, and then finally some tax administration amendments. Okay, so quite a lot of amendments again, considering what a busy year it's been and considering with all the COVID tax relief in between. So quite a lot to get our minds around. Many of these amendments, I've seen people saying they are just, technical, but I think some of them have quite a bit of impact as well. All right, so let's go straight into it then. And as I mentioned, the further COVID relief that was called for by various submissions, and National Treasury has said they may still consider certain things, but not just yet, not in these particular bills. So they said that they will look at some of the COVID-19 tax proposals that may have less impact on the fiscal framework, such as the tax residency test for inclusion in legislation later this year. So interesting that they refer to the tax residency test, and one would imagine that might also have a similar impact to what we're seeing coming through in the Section 10102 amendment. And this is an amendment that looks at the number of days that the person must be outside South Africa in order to qualify for the exemption. So, of course, the foreign employment income exemption, we're talking about Section 10102. This amendment only affects 10102, although there are other exemptions in 10101 and 10101A, but those ones haven't been affected. There's only 10102 that is affected. So it's the foreign employment income exemption, which applies to remuneration earned while a person is outside South Africa, as long as they have been out of the Republic for more than 183 days within a 12-month period. And within that period of absence, it must be a continuous period of absence of more than 60 days. Okay, so we've got that 183-day and 60-day period of absence. Now, of course, this 183-day period of absence over a 12-month period, if you had somebody who had been working outside South Africa, qualifying for the foreign employment income exemption, having met the number of days, etc., you can imagine that this would be quite a problem in terms of the travel restrictions that arose due to the COVID-19 pandemic. So we saw quite a number of people who had possibly been working overseas, China, UAE, Europe, etc., who might have had to come back to South Africa. And then, of course, having come back here, then they were stuck here for quite some time because travel was just not an option. Now, of course, this could make it difficult for the person to meet the 183-day requirement. If they're stuck in South Africa between, let's say, February and September, that takes a whole chunk out of the year. And it might be that they might have been on track to meet the 183-day requirement. Remember, it's over a 12-month period. It doesn't run per year of assessments. It's over a 12-month period that overlaps into your year of assessment. But if this person had to then come back to South Africa and was not able to travel, internationally, maybe they were still doing the work, but they were doing it here online, remotely. They were not able to travel back to where they normally would be operating from. So after submissions had been made, National Treasury did recognize that they needed to give some concession here. And so what they're focused on is our lockdown period in South Africa, specifically our level 5 and 4 lockdown, a sort of hard lockdown. Remember those days when we were stuck inside, we couldn't even walk around the block. So that was from 27th of March and then down to level 4 through to the end of May. So the number of days there, the actual number of days, 66 days, literally from March, end of March to end of May. Not business days here, obviously actual calendar days. So the idea is that during that time, people really could not travel. They were stuck in South Africa. So they've then taken those 66 days and they've simply reduced the 183 days by 66 days. So in order to qualify for the exemption, instead of saying that the person must have been outside South Africa for more than 183 days over a 12-month period, it's now 117 days in any 12-month period. Notice also that they have made this effective for the years of assessment ending 2020 and 2021. That is quite significant, and it might have certain implications, especially for employees who might not be provisional taxpayers, and they might have already submitted their tax returns for 2020. Now, on the basis of assuming that you had to meet the 183-day requirement. Now, the reason why they've changed this for 2020 and 2021 is, remember, we said that you have to be outside South Africa for more than 183 days within a 12-month period, which runs into your year of assessment. And that could be looking backwards or looking forwards into the future. So it could be, I could take my 12 months from today running until, 24th of November, 2021, or I could take my 12 months from today looking back from 2020 back to 2019, and then say within that 12-month period, I must have been outside South Africa for the requisite number of days. So if I was looking back and I was looking into my 2020 year of assessment, I would not have to meet the 183-day rule, it would be the 117-day rule, and similarly for the 2021. So it might well be that you might need to revise some of these tax returns that have gone in. You might need to ask for a revised assessment on the basis that perhaps a person didn't meet the 183-day, that they might have met the 117 days. So this is an interesting one, and I think it might result in some reassessments. Nonetheless, please be careful that it's only the 183-day rule that has changed, not the 60-day rule. Okay, so the 60-day continuous period of absence remains unchanged. Okay, right, I've got a question already. Okay, Jacques, so if someone worked here in South Africa for a UK company online from March to October, they would not be able to return to UK until October. Income earned in South Africa would then be sourced in SA and taxed here, even if the 117 days was achieved. Yeah, because the issue here is, of course, that the remuneration, and you need to really look at the detail in interpretation at number 16 here, but the exemption only applies to remuneration earned while you are outside South Africa. All right, so it must be while you are physically outside South Africa, the remuneration that you earned during that period. Okay, so yeah, it's so somebody who's actually working here in South Africa is not going to be eligible for the exemption. So have a look at interpretation note number 16. They go into quite a lot of detail on how this exemption actually works. Okay, so what has come through in the amendment, and I'm just having a look at the whole of section 10.102, just to make it clear as to what the exemption applies to. So remember that the exemption is now capped at 1.25 million rand per year of assessment. That came in with effect from the 1st of March 1st of March this year. I'm getting my years all mixed up here. But yeah, so the limit is 1.25 million. And it refers to remuneration received by a recruiter and employee during a year of assessment by way of, and then it lists various types of remuneration, virtually all types of remuneration as covered in the 4th schedule, except for stipends, which are covered in the 4th schedule, but are not listed here. But it also covers, look here, fringe benefits, any amount referred to in paragraph I. So if the person does derive any fringe benefits, you'd again have to look at the 7th schedule, work out the taxable value of the fringe benefit, and then also amounts referred to in section 8, 8B or 8C, which are your share option and share scheme payouts. Okay, so those amounts all come in, that type of remuneration could qualify. And then it talks about remuneration in respect of services rendered outside the Republic. So that's the point I was making in response to Jacques' query, is that it's remuneration in respect of services rendered outside the Republic. So you have to be actually doing the work outside the Republic by the employee for or on behalf of any employer. So it's not just South African employers, could be any employer, if the employee was outside the Republic, and this is where it then goes into the number of days. So what they've done is they've now split this. Okay, subparagraph A has been split into two parts. The one is the kind of old requirements, the general requirement that the person must have been outside the Republic for more than 183 full days during any period of 12 months, or the new requirement that applies for the 2020 and 2021 years of assessment. The person must have been outside the Republic for more than 117 full days in aggregate during any period of 12 months, which overlaps into that tax year, 2020 or 2021. Okay, so for these 2 years, we're not looking at 183 days, we're looking at 117 days. Notice that there's still the requirement that within that period of absence, there must have been a continuous period of absence of more than 60 full days. So that requirement is still there. Okay, right. So yeah, so quite an interesting and important amendment that has come through here. A lot of people are still a little bit critical that 66 days is not enough of an adjustment, because, as I say, this focuses on our lockdown period running from the 27th of March to the end of May, both days inclusive, whereas perhaps people's travel restrictions were not only affected by the South African lockdown, but also by the foreign lockdown when people were actually sent home and so on. But nonetheless, this is the amendment as we have it. Now, as I mentioned, that this affects both the 2020 and 2021 year assessment. So actually it's deemed to have come into operation on the 29th of February 2020. Bear in mind that 1.25 million limit came into effect from the 1st of March 2020. Okay, it was going to be 1 million, but remember they upped it to 1.25. So that came into effect from the beginning of this current tax year that we are in at the moment. Right. So yeah, just to finish off on that, it's interesting then that they have made this concession with the number of days, reducing 183 days down to 117, but also interesting that they've only done this for section 10102. Very, very limited application. They have given a kind of a hint that they might look at other amendments, and they specifically referred to the residence definition, which I'll talk to in a little bit more detail a little bit later on. But of course, there we look at the physical presence test. We talk about the person having been in South Africa for more than a certain number of days. And it is possible that they might then, in light of the COVID travel restrictions, give a little adjustment there. But that is not in the amendments just yet. So we'll have to wait and see whether that comes through next year. Okay, so that's the Foreign Employment Income Exemption Amendment, which has basically already come into effect. All right, then the next amendment is an amendment dealing with employer-provided bursaries. Now, this one, certainly it's a bit toned down from what the first draft was as a result of submissions that were made during the submission process. But it's still going to be bad news for quite a few employers and employees, especially the employees. It's actually the employee that is negatively affected, because it's the employee who loses the exemption. So what would happen is that if the employer provided scholarship or bursary, so that if they paid the school fees or varsity fees for the child of an employee, that would normally give rise to a taxable benefit, right? There would be a fringe benefit value. There would be a value that comes in being the cost to the employer of actually providing that bursary. However, the exemption basically gave this exemption up to a specified amount, where it's a scholarship or bursary for a relative of an employee. But nonetheless, the exemption was there, and it gave quite a bit of relief. And over the last few years, especially between sort of 2014 and 2016, which is actually quite a while ago now, it seemed like just yesterday, but it was at the time of all the fees must fall protests and so on. At that stage, this exemption received a lot of focus. And actually, the thresholds and the limits on the exemptions were hiked quite substantially, kind of sending a message to employers to say, government would like you to get on board with, providing a bit of funding to assist with the cost of education of your employees' children, to give a bit of relief to your employees. And so, I mean, understandably, many employers got on board with this and implemented various scholarship and bursary schemes. Some of them were above board and fine, but unfortunately, as often happens, you have the sort of the more dubious schemes that also come to light. And certainly we've seen SAICA has highlighted quite a lot of dubious schemes in this area. And so unfortunately, these dubious schemes kind of overshadowed all the good stuff that was happening. I think what also happened is that we saw so many schemes happening that SARS and National Treasury became quite alarmed. You've seen the projections on tax revenue collection for this year and next year, and it's looking a little dismal, to say the least. And so they were concerned about tax leakage, concerned about the loss of tax revenue. And so as a result, they are clamping down quite significantly on this exemption. So you'll see there's two parts, section 10.1Q and 10.1QA. They virtually say the same thing. And in fact, 10.1Q is the original exemption. 10.1QA is the exemption that applies when you've got a person with a disability. And it pretty much says the same thing. The only thing is that it has higher caps on the amounts of the exemption, which I'll show you just now. So in essence, what is actually exempt under section 10.1Q is when there is a bona fide scholarship or bursary granted to enable or assist any person to study at a recognized educational or research institution. All right, so bona fide scholarship or bursary, and there's got to be a recognized educational or research institution. So at that point, those are the key requirements for this exemption to apply. I'm not going to go into the detail of interpreting all of these terms. If you want to read more detail on the interpretation of what do we mean by bona fide, what do we mean by recognized educational research institution, have a look at interpretation note number 66. It's a bit outdated, it really is due for an update, but it does deal with these fundamental principles. Okay, so having set the terms of what type of, what does the exemption apply to, there's then a proviso that says, but if the exemption, if the bursary or scholarship has been granted by an employer or an associated institution to an employee or a relative of an employee, so now looking at your kind of your closed schemes, if we can put it that way, then the exemption will not apply other than in certain specific circumstances. So it starts broad, then in terms of your employer-employee bursaries, it then has certain conditions that have to be met before the exemption will apply. If the scholarship or bursary is provided to an employee, then there has to be the undertaking that the employee will refund the employer if they fail to complete their studies other than because of death, ill health, or injury. Okay, so there's got to be that condition that you have to refund if you flunk out. Okay, as far as the employee is concerned, that's a scholarship or bursary granted from an employer to an employee. If you talk about scholarship or bursary granted to a relative of an employee, then the first requirement is, so there isn't that requirement about having to refund. That only applies in the case of an employee directly. If you're looking at the relative of the employee, the key thing is that the employer must have a remuneration proxy not exceeding 600,000 a year. So remuneration proxy actually looks back to the previous year of assessment and says what was the remuneration from this employer in that year. That becomes your remuneration proxy for this year. So it must not exceed 600,000. So once the employee qualifies in terms of the level of remuneration, then you look at the actual limitations on the exemption, and I'll come to those limitations just now. Okay, so that's in terms of relative of an employee. Person with a disability, as I say, same conditions apply, they just have slightly different limitations. And that's really the conditions and the terms for the exemption to apply currently. Now, this exemption, certainly the section 10.1Q exemption has been around since the early 1990s. When it was first inserted into the legislation, it had an additional condition that said that the exemption will not apply. Excuse me a sec. The wind is coming up and my doors are banging, so let me just close the door. Okay, it said the exemption will not apply if there's any element of a salary sacrifice. So that was there for sort of 13, 14 years. And then in 2006, it was decided that that should actually be removed because it's overly restrictive. It kind of excludes many people from benefiting from this exemption who really should benefit. So they actually took the step of taking out that salary sacrifice exclusion. Now, what is happening in this amendment is they are looking at putting that back again. And that's the gist of what the 2020 amendment is all about. Initially, it started off with 3 amendments. This was in the draft bill. The first one was to say that you would not get any exemption when the employer provided bursaries or scholarships to relatives of an employee. There would be no exemption unless the employer also provided an open bursary or scholarship to members of the general public. Well, I mean, that was not a realistic proposal. For many small, medium-sized businesses, even some large businesses, they are not in a position to be providing open bursaries or scholarships. So that was criticized quite severely during the submission process, and that particular proposed amendment was then taken out. The second proposed amendment was this issue around if there's any element of a salary sacrifice, the exemption will not apply. And I'll talk more about that because that has stayed. I'll tell you exactly what the wording is. We'll come to that in a moment. The third proposed amendment said, as a further means of encouraging employers to grant bursaries basically without having any salary sacrifice, the proposal was that the employer would get no deduction if there was any element of a salary sacrifice. And of course, the criticism there is that this is now a double penalty. Not only is the employee losing the exemption, but the employer is losing the deduction. I mean, it's completely unnecessary to have a double penalty. And so, rightly so, through the submission process, they dropped that third proposal. Okay, so what stayed was the middle one around the fact that the exemption would not apply if there's any element of a salary sacrifice. So what remained unchanged, this is not changed this year, is this remuneration proxy still is 600,000. So in order for the exemption to apply, so first of all, if you're talking about a bursary or scholarship to a relative of an employee, remember it's got to be bona fide. They've got to be studying at a recognized educational research institution. The employee must have a remuneration proxy not exceeding 600,000, and then the amount of the exemption is capped. So if your relative is studying grade R all the way through to the end of school, grade 12 or NQF level 4, then the cap is 20,000 Rand per relative per year. So if you have 6 children, it'll be all studying at school, it'll be 6 times 120, if they'll get a bursary, of course. Okay, if it's a person with a disability, that exemption threshold goes up to 30,000 Rand. If it's that the relative is studying at a post-school level, all right, NQF level 5, which is like first year varsity or first year out of school, right through to NQF level 10, which is your PhD level. So there, your cap on your exemption, 60,000 Rand per relative per year, up to 90,000 if it's a person with a disability. Okay, so those have not changed this year at all. And I mean, bear in mind that the 600,000 now hasn't changed since 2017, so we're a little bit lagging in terms of inflation, etc. And in terms of those limitations, the caps on the exemptions also haven't changed since 2017. So I think that's one thing that we talk about Annexure C, that's amendments. That is certainly something that they need to consider, is the monetary thresholds. Many of these monetary thresholds in the Act are really quite overdue for amendments. Okay, I'm just making a note to myself here to raise that as an Annexure C item. Okay, so those thresholds are still the same. Now, the issue is that what has come through as the amendment is basically this proviso that says that there'll be no exemption unless you meet these certain criteria. This particular part says there'll be no exemption if any remuneration to which the employee was entitled or might in the future have become entitled was in any manner whatsoever reduced or forfeited as a result of the grant of such scholarship or bursary. So here's this wording around any element of a salary sacrifice. It's extremely broad in its application. And interestingly, it's actually exactly the same wording that they had back prior to 2006 that they've just gone and copied and pasted, stuck it back there again. But let's just explore this for a moment, because many employers have implemented salary scholarship and bursary schemes that do look at some kind of salary sacrifice. Now, of course, to be a valid salary sacrifice, to my mind, means that you can't be sacrificing something that has already accrued to you, that you are already entitled to, okay? Because once you have an entitlement to something, you have a tax liability on that. So in order to be a valid salary sacrifice, you must be sacrificing something that may be coming up in the future. Like maybe you could be getting a 5% salary increase on the 1st of January next year. You're certainly not entitled to it now, but perhaps it's something that is, you know, possibly under discussion with the employer. And then the employer would say, okay, but on the other hand, we can give you no salary increase. And then rather what we would have spent on the increase, that cost to company, we can use that money to fund scholarships or bursaries. Now, that would come squarely into this part that says any remuneration to which the employee might in the future have become entitled. Okay, so it's not just something that they have already become entitled to. No, you can't salary sacrifice that. It's also something that you might have become entitled to in the future, but now you are forfeiting. It says in any manner whatsoever. I think that's pretty broad. In any manner whatsoever reduced or forfeited as a result of the grant of such scholarship or bursary. Okay, so I think that really means that if there is any element of a salary sacrifice involved with the scholarship or bursary scheme, then the exemption is not going to apply, which means that whatever the employer then spends paying for school fees, varsity fees, etc., for relatives of employees is going to give rise to a taxable benefit. It's part of remuneration, it becomes taxable, and there's no exemption to give any tax relief. So quite an unfortunate amendment, I think, for many employees and employers. And I think it could well sound the death knell to many of these schemes that have sprung up. So the effective date, of course, this is important. It will come into operation from the 1st of March 2021 and apply in respect of years of assessment commencing on or after that date. So it'll be for the next year of assessment. So for this year of assessment, anything existing is still according to the existing rules, but from the beginning of the following year of assessment, you're going to lose this exemption if there's any element of a salary sacrifice. Okay, so please be very careful of that. And if you are dealing with clients who have entered into scholarship and bursary schemes, I think the earlier they're warned about this, the better, because they might well be in salary and wage negotiations now for next year. And I know that some employers have already sort of made promises to the unions that, well, you know, we'll have less of an increase, but then we'll do this bursary scheme. I think then, you know, you are looking at a salary sacrifice situation, and then the bursary scheme is not going to help because there won't be the exemption available. You might be better off rather putting the money in the hands of the employees and letting them have the freedom as to how they want to spend that money. Remember also, and I mean, you can get a sense of this if you look at interpretation note number 66, is that the administrative burden of overseeing a scholarship and bursary scheme is quite huge as from the employer's point of view. They have to, of course, satisfy SARS on the fact that it's bona fide. They have to make sure that they keep all the paperwork, the documentation, to make sure that it is a proper payment of your university fees, etc., that has actually gone to the university. So there's a lot of admin involved in overseeing these scholarship and bursary schemes. So if you're going to lose the exemption, then it seems that it might be questionable as to whether it's still worth having the scheme. Okay, but that you would need to make a call on depending on the particular circumstances. Right, so there's the amendments as far as the bursaries are concerned, and as I say, it comes into effect from the beginning of the next tax year. Righty. Okay, then the next amendment dealing with withdrawal from retirement funds. Now here you'll see that the amendment is to Section 1 of the Income Tax Act. So these definitions in Section 1 are critically important because in order to be an approved fund, it has to be a fund that meets the definition set out in Section 1. So if your contributions to the fund are going to qualify for deduction under Section 11F, it has to be an approved fund. It's got to meet these criteria. If your payouts from the fund are going to get preferential tax treatment using the special tables, again, it's got to be an approved fund meeting these definitions. Okay, so that's why what is said in these definitions is very important and has to be then carried through to the actual rules of the relevant funds. So in this case, you'll see that what is changed here are the definitions of pension preservation fund, provident preservation fund, and retirement annuity fund. Okay, so just those three types of retirement funds. So when we see preservation fund, so we already are seeing here, it's not talking about pension fund per se. It's talking about pension preservation fund, provident preservation fund. Okay, so it's talking about somebody who has actually transferred their retirement benefit from a pension or provident fund into a preservation fund. Okay, the money is now in this preservation fund. And the question is, when is the person allowed to take their money out of the preservation fund? Now, of course, being a preservation fund, there is the fundamental rule that you are allowed one withdrawal at some stage from the preservation fund. So that is there, and it's not linked to what we are going to be talking about now, which is talking about taking your money out when you immigrate. So there is still the possibility, if a person is a member of a preservation fund, they might be contemplating immigration. They don't specifically have to rely on the immigration rule, perhaps, to take their money out of the provident preservation fund. They could rely on that one withdrawal rule to take their money out. Okay, but when you look at a retirement annuity fund, you don't have that one withdrawal rule. Generally speaking, you put money into a retirement annuity fund, you can't touch that money until you get to at least 55 years of age, right? And then, so there's not really a withdrawal option apart from this immigration option. There's only the retirement option, and that means that when you get to the age of 55, you could then take up to 1/3 of your total benefit as a lump sum, the other two converting to an annuity. Okay, so I make this point because I want to highlight that these amendments that are coming through are particularly onerous for members of retirement annuity funds. Members of preservation funds have another option, but members of retirement annuity funds have no other option, except the concession that is granted when a person immigrates. Now, currently, the concession that is granted, and you see exactly the same little sentence in each one of those definitions, it says that the one time when a person can take money out of their fund is when prior to their retirement, so prior to retirement date, right? So we're talking about a withdrawal benefit. They would be entitled to the payment of a lump sum benefit where the person is or was a resident who immigrated from the Republic, and the immigration is recognized by the South African Reserve Bank for purposes of exchange control. So a person ceases to be a resident as defined, and they immigrated from the Republic, and the immigration is recognized by the Reserve Bank. Now, SARS and National Treasury have two reasons for the amendment that is going to come. The one is that this particular concession is focusing very much on the Reserve Bank approval, looking really at your whole financial immigration, which has caused a huge amount of confusion amongst, I think, tax practitioners and taxpayers alike. And I think SARS and National Treasury, realizing the confusion and realizing that many people seem to be conflating this idea of financial immigration and the question of a person ceasing to be a resident. You see, a lot of people have interpreted financial immigration as saying, well, as long as you've financially immigrated, then you cease to be a resident. So they're conflating it. But actually, that is fundamentally incorrect. The definition of resident in Section 1 of the Income Tax Act is very specific. And if you have been ordinarily resident and you cease to be ordinarily resident, it's a change of a state of mind. We'll look at this just now when you look at the definition of resident on a later slide. And so you would have to demonstrate that you've actually ceased to be ordinarily resident. Now, it might be that you are shifting your real and permanent home, you immigrating, and you are applying for ex-con approval, all right, to take your assets out of South Africa. But you can't say that just because you're applying for ex-con approval, that means that you are ceasing to be a resident. Okay, so this issue around financial immigration and the confusion that has been caused was one of the driving forces of this amendment that's going to come through. But also linked to that was the announcement by the government, the Minister of Finance, in the 2020 budget speech, that they're going to be modernizing the exchange control system and putting a new system in place, moving away from a negative list to a kind of allowing a lot more, but looking at a risk-based list of capital flow measures. Okay, so we are already seeing some movements in this regard, and we're going to see some other amendments coming through later, also linked to this issue of relaxing exchange controls. So looking at all of this together, what SARS and National Treasury are wanting to do then in terms of these rules, instead of relying on the Reserve Bank approval, they want to move away from that and just get back to the tax definition of resident. When a person ceases to be a resident, then they would be allowed to take the money out of the fund. But what they are concerned about then is when a person ceases to be a resident and then becomes a resident again shortly thereafter. Now, let me just show you the amendments and then I'll explain a little bit more about when this might happen. So if we look at the actual amendments to the three definitions, so they all say, this little paragraph says exactly the same thing in the definition of pension preservation fund, provident preservation fund, and retirement annuity fund. And they say that in essence that a person may take a benefit before retirement, right, or a withdrawal lump sum, in other words, if he or she is, now they split this, A and B. So A is basically the old rules. And they're saying the old rules will apply for any application that reaches the Reserve Bank up until the end of February next year, as long as it's approved within 1 year after that. Okay, so let's pick it up there. It says, if the person was or is a resident who emigrated from the Republic and that immigration is recognized by the Reserve Bank for purposes of exchange control. Okay, so that's exactly where we were before with the old rules, but this only applies, as you can see, for applications that reach the Reserve Bank on or before the 28th of February 2021, or an authorized dealer for the delivery of currency on or before the end of February 2022. Okay, so old rules apply for applications that are lodged with the Reserve Bank up until February next year. From the 1st of March next year, we then move away from this reliance on what the Reserve Bank has approved. We move away from this kind of financial immigration concept, and we move into the new rules, which say that you can take your withdrawal lump sum from these three types of funds if the person is not a resident, so they've ceased to be a resident in terms of the definition of resident under Section 1. But then, note this, they have to remain a non-resident for 3 years before they can actually take their withdrawal benefit. So this 3-year delay, this is what's caused a lot of unhappiness with this amendment, is that you might cease to be a resident, but you still can't take the money out of your fund until you've remained a non-resident for an uninterrupted period of at least 3 years. Okay, so under these new rules, and as I say, they come in from the 1st of March 2021, we are then looking at this definition of resident. Now, let's just consider this definition of resident in Section 1 as far as individuals are concerned. So we typically talk about having two tests, the ordinary residence test and the physical presence test. The ordinary residence test is your test, basically that's when this is the person's real and permanent home. So typically somebody has either immigrated here, like they've moved from Zimbabwe to South Africa, this has now become their real and permanent home, or perhaps the person was born and raised in South Africa, this has always been your real and permanent home. So how do you determine if a person is ordinarily resident? We don't have any statutory tests in this regard. We rely on common law tests. We look at case law. We've got our two pivotal cases, the Cohen case, which goes back to the 1946, World War II. Cohen, who was involved in the OK Bazaars, one of the founder members, went and spent time in New York, and it actually related to dividend exemption, but it looked at whether he had changed his ordinary residence. But the point of the matter is it's a very old case, and it looked at basically this whole idea of where is your real and permanent home, where is the place you return to after your wanderings, and so on. Then there was the later case of Kutel, who was a yachtsman, participated in various yacht races, especially that old Whitbread round the world yacht race. But he literally moved from port to port, lived in various places around the world. And the question was, you know, where was his real and permanent home? Where did he return to after his wanderings? And so those two cases now, you know, some of you, quite a few of you, I think, might not even have been born in 1970 or so when the Cohen case took place. Certainly many of us were not born in 1946 when the Cohen case took place, and the Kutel case, sorry, was in the 1970s. But these are very old cases. That's the point I'm making. And we haven't had any update on this. We still rely on the same old principles. What we do have is the SARS interpretation note number 3, which lists all the different principles that might indicate a person's state of mind. might indicate when they have ceased to be a resident, etc. But it can be quite difficult, and it's certainly not time-based. So you can't say once a person has been outside South Africa for 3 years, they cease to be resident. We don't have a rule like that. It is definitely a rule based on state of mind, and the onus, of course, on the taxpayer to demonstrate that they have ceased to be a resident. So that's the one part of the rule. Then we have the physical presence test. Now, this is really a test that expands the scope of who is a resident in South Africa, and it brings people into the definition who would not otherwise be there. So it applies to people who are not ordinarily resident, someone who is not at any time during the year of assessment ordinarily resident, okay? So we've established they are not ordinarily resident. So they are people who have been ordinarily resident in another country, but they spend more than a requisite number of days in South Africa. And then you do this test on a year-by-year basis. And if in that particular year, the person has met the physical presence test, then they become a tax resident, and they're taxed as a tax resident for the whole of that year. So you really have to look over a 6-year horizon. You look at your current year of assessment, and you look at the 5 previous years. And you say, in the current year, was this person in South Africa for more than 91 days in aggregate? Okay, and you can come and go, come and go, come and go. But in total, were they here for more than 91 days? In the current year, in each of the 5 previous years, so for 6 years concurrently, they must have been here for more than 91 days in every single year. And in addition, when you look back over the last 5 years, in total, the number of days they spent here in the last 5 years is more than 915 days. So on average, more than 183 days per year over the 5 preceding years. So it's literally a case of if they spend enough time in this country, they become resident under the physical presence test. And this is the point I was making under the COVID-19 travel restrictions, as you might have someone again who was kind of stuck in South Africa. They didn't want to be here for more than 91 days, but they couldn't leave. And now they end up meeting the physical presence test, and they end up being a resident, which has all sorts of tax consequences. So these are the 2 tests that we typically look at in terms of saying, is this person a resident? Now, in terms of withdrawal from the funds, we're saying the person has ceased to be a resident and they remain non-resident for an uninterrupted period of more than 3 years. It raises this important point that not only is a person ceasing to be a resident possibly because they've shifted their ordinary residence, or they're moving out of the physical presence test, they stay out of South Africa for 330 days, they then cease to be a resident. But there's also an overarching exclusion that says excluded from the definition of a resident is any person deemed to be exclusively a resident of another country for the purposes of a double tax agreement. And we are seeing this more and more with our migratory working situations, people working all over the world, divers going and diving, and people, could be anything, IT people, you name it, travel people, airline captains, air stewards, people working on ships, people working in all manner of different ways, even us accountants, we have people working all over the world. So the issue is that if you go and work in another country outside South Africa, and then in terms of a double tax agreement, you end up being regarded as exclusively a resident of that other country for the purposes of the DTA, then you cease to be a resident from South Africa's perspective, okay, because you're excluded from the definition. So you could still come into that scope of ceasing to be a resident, but perhaps, and this is what SARS and National Treasury were concerned about, is that you go work somewhere else, you cease to be a resident because you're now a resident there under the DTA, then you stop working there, you come back to South Africa, and now you become a resident once again. But now because you cease to be a resident, you've taken your money out of the fund, the preservation fund or the retirement annuity fund. So the concern is that they're worried that people then come back having depleted their retirement savings and now becoming dependent on the state. Let me just show you quickly under DTA how you would determine if a person is exclusively a resident of the other country. So first of all, if you have somebody, let's say from South Africa, resident in South Africa, they've lived and worked here, got their degree here, then they go and work in the UK or France. So obviously you would then pick up the relevant double tax agreement, and you would look at that double tax agreement. And the whole point of applying a double tax agreement is you have to establish in which one country is this person a resident. So you look at the article of the double tax agreement, which has the definition of resident. And typically with the OECD model tax treaty, which governs the DTAs entered into with our sort of first world countries, then we've got the UN model tax treaty, and it says a very similar thing with resident. So basically we're saying a resident is a person who's liable to tax in one of the countries because of that person's domicile, where they're living, their residence, place of management, or any place of management obviously normally refers to businesses. So if we're talking about individuals, don't worry about that one, or any other criterion of a similar nature, but excluding someone who's liable to tax in that country only because of the source principle. Okay, so if the person is domiciled or resident in the other country for a period of time and they become taxed in that country, they could potentially be a resident. Now, according to the rules of other countries, this could happen even after 30 days in the case of the Swiss DTA and the Swiss tax rules. In the case of many other countries, it could happen after they've been there for, let's say, 183 days, and various different rules. It goes country by country. So they might be then regarded as a resident for that country's tax purposes. But if this person still has ties to South Africa, they haven't really emigrated from South Africa, they're still regarded as ordinarily resident here, then they're now resident in both countries. You would then apply the tiebreaker clauses to establish one country where that person is a resident. And the DTAs all have these similar tiebreaker clauses, literally going in a hierarchical fashion, 1, 2, 3, 4, 5. First of all, do they have a permanent home available to them in one country? And that's not necessarily a fixed structure. It could be a caravan or a boat, but do they have a permanent home? It also doesn't necessarily mean that they have to own the home. They might have a rental on the home. Now, it might be that this person has homes in both countries or no countries. So if you can't establish one particular residence there, then you go to the next one. What is the center of vital interest? Looking at their personal factors, the location of employment, lifestyle, personal relationships. If that's not conclusive, you go to the next one, which is habitual abode, where they spend the majority of their time. If you still haven't found one country where they particularly are a resident, then you go to nationality, home affairs, where do they have permanent residence, etc. If you still haven't got one country where the person's resident, then this matter will be resolved by mutual agreement between the two parties to the DTA, the two countries. Okay, so the idea is under the DTA, you would establish one country where the person is a resident. If it is that the person is deemed to be exclusively a resident of the other country, like UK or France, then they are not resident in South Africa. Okay, so they've ceased to be a resident of South Africa. But in terms of this amendment that I'm talking about with the funds, they still can't take their money out of the fund until they have remained a non-resident for an uninterrupted period for 3 years. Okay, right. Let me pick up a couple of questions on this. So with Gillian's asked, with reference to the withdrawal lump sum on immigration, can the application to the Reserve Bank be made before actually physically leaving the country, with visas having been approved, or must the physical immigration? Yeah, you can apply before you physically leave the country. In fact, in many cases, you would need to get this approval before you actually physically go. Once immigration has taken place, visits back to South Africa, as long as they don't exceed 91 days, would not break the 3-year residency test. Yeah, so the issue, yeah, so visits back here, that's okay as long as it doesn't cause you to change your residency. But I think, so be careful also in terms of the DTA. You know, what is the DTA saying about if you've shifted your residence because of the application of the DTA, and you then cease your employment there, come back to South Africa while you wait for another job. It goes without saying that you would no longer be regarded as resident in the other country, then you are resident again in South Africa. All right, if someone immigrates to another country and has permanent residence there, but continues to earn income from a business in South Africa, are they considered to still be a tax resident in South Africa? No. So the fact that you're operating a business in South Africa would not make you tax resident here. As I say, your definition of resident, we go back to that section 1 definition. Let me just scroll back to the previous slide. Oh, sorry, I've gone the wrong way. So there's my definition of resident. Okay, so it's with your ordinary resident, looking at factors that would indicate residence and whether you've changed your residence, have a look at interpretation note number 3 for more information on that. And then, of course, the physical presence test. So there's nothing, the only possible linkage could be this issue around center of vital interests, location of employment, etc. But just the mere fact that you happen to have a business operating in South Africa doesn't, and I'm assuming as a sole trader, right? I mean, if it's a company operating in South Africa, that's a different story. We're talking about individuals here. Okay, so I hope that has answered that question. Let me just see if there's another one there. Yeah, sole trader. Okay. Right, good. Okay, so that's that issue. So to get back to this amendment, so basically what it is saying is that from the 1st of March next year, if the person ceases to be a resident, and I've gone into a whole long discussion around how you cease to be a resident, different ways that you might cease to be a resident, but you can only then take your withdrawal benefits out of the preservation fund and the retirement annuity fund if you remain non-resident for at least 3 years. Okay, then you'd be able to take your money out of the fund as a withdrawal benefit. As I say, if you've already reached retirement age, then this amendment doesn't really affect you, because this is talking about people who want to take money out of the funds before they get to retirement age. Okay, great. Let's have a look at the next amendment. Okay, so Section 7C, our old perennial favorite, right? So Section 7C has been with us for a few years now, created quite a few shockwaves in the trust industry when it was first introduced back in 2016. And of course, the effect of Section 7C is that it creates a deemed donation. All right, so if Section 7C applies, then there's a deemed donation, and that deemed donation would then carry donations tax liability. All right, so what does Section 7C actually apply to currently? So currently it applies in terms of loans made by either a natural person or a company at the instance of a natural person who is a connected person because they hold at least 20% of the shares in that company. Okay, so the lender. So in terms of determining when Section 7C applies, you need to go through these inquiries. Who is the lender? Is it a natural person or a company that meets that criteria? Who is the borrower? The borrower is either a trust or a company. A trust in relation to which the lender, that individual behind the loan, okay, if that person is a connected person in relation to the trust that is the borrower, then Section 7C would apply. Now, of course, you've got to look at this definition of connected person. And if you have a trust, who is a connected person in relation to a trust? Any beneficiary of the trust and any relative of the beneficiary, etc. So, and any connected person who's a connected person to the connected person. Okay, so it can go on. But I mean, if you have Joe Bloggs, who is the founder of a trust, the beneficiaries of the trust are his 2 children, he is a connected person to the trust because he's related to the beneficiaries, and so you complete that connected person circle. So then if Joe Bloggs is the lender, he's a natural person, lending to a trust, okay, trust, yes, and we've got the connected person relationship, then we are into the scope of Section 7C. Now, very soon after the Section 7C was launched, they then expanded this to also include loans to certain companies. So again, the same lender, natural person or company at the instance of a natural person. In this case, the borrower is a company, but it's a company, at least 20% of the equity shares of which are held either by a trust that is a connected person to the individual behind the loan or by a beneficiary of that trust. Okay, so you've got trust holding shares in a company if it holds at least 20% of the equity shares or voting rights in that company, or a beneficiary of the trust holds those shares or voting rights in the company. And remember, again, we need to have the connected person relationship, that the trust is a connected person to the individual behind the loan. All right, so then Section 7C would apply. So in short, currently, Section 7C applies where we've got loans basically from or at the instance of a natural person to a trust or a company held by a trust, and where we've got that connected person situation. what is the effect of Section 7C is that when it applies, you would then say, what is the amount of the loan? What would the interest be if you had used the SARS official interest rate? And remember, that varies from time to time because it is linked to the repurchase rate set by the Reserve Bank. And we've seen that rate come down, down, down over the last few months. So you would work out what would the interest be using the SARS official rate minus what interest has actually been charged on that loan. And then if there's any shortfall, so let's say if we said, for example, the loan was 10 million Rand, if we said the SARS official rate was, let's say for argument, 5%, I'm just using that as an example, then the interest for the year would be 500,000 using the SARS rate. How much interest has actually been charged on the loan? 0 if it's an interest-free loan. And so the interest foregone is 500,000. So that interest foregone is then deemed to be a donation for the purposes of donations tax. It's a donation deemed to be made by the individual behind the loan to the trust and deemed to be made on the last day of the year of assessment of the trust, but that would be end of February in any event, same year of assessment as the individual. And so you would then have a deemed donation. Yes, you might be able to use your 100,000 Rand exemption if you haven't already utilized it against another donation during the year. And then whatever you're left with is going to be taxed at the donations tax rate. 20%, but of course it does go up to 25% once the donor's cumulative donations exceed 30 million Rand. Now, there are various exemptions. I'm not going to go into those. So that's the effect of Section 7C and the scope of Section 7C as it currently applies. Now, the amendment is to say, well, we now want to bring preference share structures into the scope of Section 7C. So this new subparagraph is going to be inserted into Section 7C immediately after Section 7C 1A, which is the one that is there. Well, it's currently Section 7C 1 is going to become 1A. That's the current scope. And then there'll be 1B, which is the additional scope. Okay. And 1B says, again, the person behind this deemed loan now, natural person or a company at the instance of a natural person who is a connected person because they own at least 20% of the shares. So again, this kind of lender, the investor in this case, same scope, this individual person. But now, of course, there's no actual loan. But what we have got is preference shares. So we're saying if this individual or the company at the instance of the individual subscribes for preference shares in a company, what kind of company are we talking about? It's the same type of company, the one in which 20% or more of the equity shares are held or the voting rights are exercised by a trust that is a connected person in relation to that natural person. Okay. So it's the same type of company held by a trust. So we've got this company, at least 20% of the equity shares are held by the trust, but then the company has also issued preference shares, and the preference shares are held by a natural person or by a company at the instance of a natural person who holds at least 20% in that company. Okay, so basically it's the same type of company, but now it's got preference shares in addition to the equity shares. Now, there's no loan that features here. Remember that the normal Section 7C1 talks about a loan, advance, or credit that has been made by this individual or company. Here, there's no loan, advance, or credit, but we've got the individual or company has subscribed for the preference shares in this company, which is partly owned by the trust. So the issue is that that amount of the subscription for the preference shares, the consideration received by a recruit to the company for the issue of the preference shares is now deemed to be a loan. Okay, so if this company had issued preference shares and raised 10 million Rand from the issue of the preference shares, that consideration of 10 million Rand for the issue of the preference shares is now deemed to be a loan. Okay, and if these other requirements have been met, we are into the scope of Section 7C, and we now have a deemed loan of 10 million Rand. Then we have to go through the same determination of saying, right, what would the interest be on this deemed loan if we use the SARS official rate of interest? Okay, let's assume, same example that I used just now, if that interest rate was 5% on 10 million, 500,000 would be the interest on this deemed loan if we use the SARS official rate, minus how much interest has actually been charged. Well, we don't have actual interest because we don't have an actual loan. We've got a deemed loan. But what comes through is this last part. It says any dividend or foreign dividend declared in respect of the preference share is deemed to be the interest. So we've established that we've got a deemed loan of 10 million Rand in my example. SARS official rate of interest at 5% would trigger interest of 500,000 for the year, minus what dividends or foreign dividends have actually been paid in respect of those preference shares for this year of assessment. If maybe 200,000 Rand, let's just assume. So we've got a difference between the 500,000 and the 200,000. And so there's a difference of 300,000. That 300,000 then becomes your deemed donation for the purposes of Section 7C. So the natural person is deemed to have donated to the trust that difference of 300,000. And then that could trigger donations tax in the same way as we saw with the existing application of Section 7. Okay, so this is coming through with effect from the 1st of January 2021. I'll come back to the effective date just now. But let me also mention this definition of preference share for the purposes of this provision. So this was one of the calls that came through in the submissions is, what do you mean by preference share? Can we please have a definition? So they've imported the definition from Section 8EA, which is one of the other provisions of the Act, doesn't really have any specific relevance right now. The important thing is when we talk about preference share for this purpose, it means any share either other than an equity share, or it could even be an equity share if the amount of dividend or foreign dividend in respect of that share is based on or determined with reference to a specified rate of interest or the time value of money. Okay, so if you've got a kind of a fixed return, a fixed dividend policy on your share, that would indicate that it is a preference share. Now, normally you wouldn't find that with equity shares because you don't normally have a specific entitlement to dividends. But if you did have that particular type of entitlement, it could mean that that is still also construed as a preference share, and then it comes into the preference share treatment. Okay, so do be careful of this. This amendment becomes effective from the 1st of January 2021 and applies in respect of any dividend or foreign dividend accruing during any year of assessment commencing on or after that date. So notice here, it doesn't apply to any preference shares issued on or after that date. It talks about dividends or foreign dividends accruing on preference shares on or after that date. So it could be preference shares that might have been issued years ago, 10 years ago, all right? But now you would have to look at the structure, all right? Who is the, what is the company shareholding? Does it come into the scope of Section 7C? Is it a natural person or a company at the instance of a natural person who has subscribed for these preference shares? If we are into the scope of Section 7C, then you would have to do the calculation, work out the deemed loan, work out what the interest would be using the SARS official rate, minus the dividends actually paid on the share during any year of assessment commencing on or after 1 January 2021. So logically, I mean, our next year of assessment is going to start from the 1st of March 2021, run through until the end of February 2022. So during that year, you would have to see what dividends have been paid on these preference shares, see if there's a shortfall amounting to a deemed interest foregone that's going to give rise to the deemed donation. So the first deemed donation under this provision would be deemed to be paid at the end of February 2022. Okay, but no good waiting until then before you feel the pain. You need to be able to identify basically any preference share structures that are going to fall into this scope. So do be careful of this. If any of you are dealing with trusts that have preference share structures, watch out for this. Watch out for the application of Section 7C from the beginning of the next tax year. Right, I see that there were a couple of queries that came up here. Okay, so Jerry's asked, what about unpaid distributions due to beneficiaries? Going back to that old question, this is a huge issue that has been around ever since Section 7C came in, around whether, is it in fact a loan, advance or credit? And is it in fact a loan? I think if you're a SAICA member, you should get hold of the tech talk that they did this morning. They spoke about this in quite a lot of detail. It's really important. I can't just give you a glib answer on this because you've got to look very carefully at the facts and circumstances. And the idea is that, is it a loan? Remember that Section 7C, so this question doesn't relate to preference shares. It goes back to the original form of Section 7C, which applies to any loan, advance, or credit. So the question is whether your beneficiary, in not drawing out that distribution, is making a loan, advance, or credit to the trust. Okay, so it comes back to that question, and that you would have to determine based on the specific circumstances presented to you. Okay. Anonymous says, can you see any potential tax implication if a person borrows money interest-free from a trust and is required to repay the trust? Look, at face value, Section 7C wouldn't apply because it's the lender. Who is the lender is the trust. 7C applies where the lender is the natural person or the company at the instance of the natural person. Of course, there are other issues that you need to look at, substance over form, etc. Is it an international loan, or is it all within South Africa, only between residents? So you do need to consider these things, but as long as everything is absolutely vanilla and straightforward, then there would not be any tax implications there. Okay, all right, so that's the amendment to Section 7C, and as I say, watch out for it coming into effect from the beginning of the next tax year. Right. Just close that down. Okay, then on to the next amendment, Section 8. All right, so Section 8 dealing with allowances, reimbursements, etc. And basically Section 8(1)(a)(1), which is the precursor to what I'm showing on the screen here, talks about the fact that you have to include in taxable income any amount paid or granted as an allowance or advance, but excluding deductions. Like if you get a travel allowance, you get the allowance, but you claim certain deductions, right? If you get a subsistence allowance, there's a certain amount that is tax-free. So apart from that, the balance would become taxable. But excluded from taxable income, and this is where we get into what we're talking about here, Section 8(1)(a)(2) says that you do not include, so they will not be included in taxable income, any amount paid or granted as a reimbursement or advance, as long as certain conditions are met. So it says currently that when you've got a reimbursement or advance for expenditure incurred by the recipient on the instruction of the principal, in the furtherance of trade of the principal, where the recipient must produce proof, so they've got to account back to the principal that the expenditure was incurred as required, then you're looking at a straight-off reimbursement, and that reimbursement would not be taxable. So it's worth looking at this. I think many times people just glibly say, oh, reimbursements are not taxable, you know. Well, reimbursements are not taxable if they meet all of these criteria. And so if we have an amount paid as a reimbursement, it has to be on instruction. So the expenditure is incurred by the recipient on behalf of the principal, on the instruction of the principal, in the furtherance of trade of the principal, and you've got to have the accounting back to the principal for the expenditure. There's also the proviso that says if it results in an asset, the asset belongs to the principal, which figures because, you know, this is expenditure incurred on behalf of the principal. Okay, so that's what Section 8(1)(a)(2) says currently. Now, obviously a thing that has been brewing over the last few years, because this can't be a new situation, it must have been something that has become problematic over a number of years, is this issue around people who travel away from home, not overnight. So we're not looking at the subsistence allowance, but they travel away for part of a day, and then they incur expenditure on behalf of their employer, and they claim a reimbursement. Now, generally speaking, I'm sure many people just say, well, that's a straight-off reimbursement, right? It's not taxable. But in the explanatory memorandum, SARS and National Treasury identify that it gets a little bit more complex than that, because you've got to look at those criteria that I just showed you on the previous slide. And so the issue arises when you've got an employee travels away on a day trip, pays for meals, incidental costs like lunch, Uber, Gautrain, airport parking, in the furtherance of the employer's trade, and then they claim a reimbursement. I'm sure many of us would just say, great, well, that's a straight-off reimbursement, it's not taxable. But SARS has taken the approach of being very strict on the wording in Section 8(1)(a), and just to highlight, it said here, on the instruction of his or her principal. So they say that in order for it to be a reimbursement, there has to be an explicit instruction by the employer that the employee must incur these costs. And if the employee is not explicitly instructed, then it's not a real tax reimbursement, it's actually a reimbursement that's subject to tax. Well, this is raising, of course, all sorts of problems if this is the approach they're going to take. I mean, I'm not sure that everybody has always ensured that their paperwork includes proof of specific instruction by the employer. And, you know, how do you discharge the onus upon you if you don't have this in writing? So they make the point that the employee might be away from home on a day trip, they incur expenditure, they want to get a reimbursement, and it should be excluded from taxable income. But on the strict wording of the Act, if you don't have that explicit instruction from the employer, it could become problematic. And so at least they are trying to make this more practical, more pragmatic. They're saying that they're going to change the wording of this provision to basically say, as long as the employer has a policy in this regard, maybe not a specific instruction. And then there would be the exclusion from taxable income, but also looking at up to a fixed daily rate. So currently, with the subsistence allowance, we have the fixed daily rate of 452 Rand per day if we're talking meals and incidental costs, or 139 Rand per day if it's just incidental costs. So presumably we'd be working around those limits. We'll see what this is when we get the regulation after the budget speech next year. But those are the daily rates that apply for the subsistence allowance. So what is going to come through is that they're rewording that provision, all right? So it basically says that the amount that will be excluded is the reimbursement on the instruction of the principal, or, okay, so you might have a specific instruction of the principal, or alternatively, where the recipient is allowed by the principal to incur expenditure on meals and other incidental costs, while the recipient is, by reason of the duties, obliged to spend part of the day away from their usual place of work or employment, but up to this daily rate that will be gazetted. So not only where it's instructed, specifically instructed by the principal, we're allowed, and that's looking at where the principal, the employer, has a policy that allows the person to travel, incur expenditure, and claim a reimbursement. So I guess the key thing is to ensure that with your clients, that the clients do have a policy around this. Sometimes, you know, it's just expected. Okay, people travel, they claim a reimbursement. But where's the policy that actually allows for that? So it's important maybe just to document that, to make sure that there is a policy around this. Otherwise, it's going to become extremely problematic if these reimbursements end up being supposedly taxable. It means there should have been employees' tax withheld. You're going to have late payment of employees' tax, penalties, interest. It just gets very problematic. So make sure that you do meet the criteria for the reimbursements to be tax-free. I think that's the warning that's going out there. So this kind of more relaxed wording, or more kind of broad wording, will come into effect from the 1st of March 2021. But I think already it's sending a warning to people that if SARS does a payroll audit and they look at reimbursements, they're going to be looking to see whether there was a specific instruction from the employer to the employee saying you must incur expenditure and you must claim a reimbursement. So it's worth just spending a bit of time if you're doing any kind of compliance checks on your clients to make sure that they do have the necessary paperwork in place for this. All right, so now let me just see here. Sorry, I'm just battling a little bit with my mouse. I think there was a question. Okay, sorted. And how are we doing time-wise? Okay, we can talk a little bit about the doubtful debt allowance, and then we'll take our break. So the doubtful debt allowance, Section 11J, as you know, underwent a substantial amendment in 2018, effective from the 1st of January 2019. And that's when in fact, I don't even know why we still call it the doubtful debt allowance, because it's not really looking at that issue any more specifically. It's not specifically saying the debt has become doubtful. It's linked to impairment of debt under IFRS 9, or if the taxpayer is not using IFRS 9, it's simply looking at debts that are outstanding beyond a certain date. So more than 60 days or more than 120 days. Okay, so nonetheless, we still call it the doubtful debt allowance. Now, what has changed? It's basically, there's two changes here. One affecting taxpayers that are using IFRS 9, and another affecting taxpayers who are not using IFRS 9, but they're different changes coming through. The change that affects taxpayers who are using IFRS 9 basically is looking at this whole question of lease receivables. So currently, if you've got a taxpayer using IFRS 9, which is looking at impairment of financial assets, your allowance under Section 11J is either 40% or 25%, and 40% looking at your IFRS 9 measurement, 25% looking at your loss allowance under the impairment of IFRS 9. But in both cases, it's talking 40% or 20% of the actual loss allowance under IFRS 9, but excluding lease receivables. So it doesn't apply to lease receivables. Now, the reason why they left lease receivables out of the doubtful debt allowance is because the way that you account for lease revenue for accounting purposes is very different to what we do for tax purposes. And the idea is that you shouldn't get the doubtful debt allowance on any amount that has not previously been included in income. So they were concerned that this confusion on the accounting for leases was going to distort the calculation of the doubtful debt allowance. However, they have identified that it has resulted in negative consequences, especially the property rental industry, and I can imagine this year having taken such a hit with the COVID-19 situation. And of course, if you're in the property industry, you've got lease receivables. If those lease receivables are not being received, you want to claim the doubtful debt allowance. So fortunately, they have now realized that this is necessary, and so they've now amended. So that basically everywhere where it used to say debt other than lease receivables, they've now taken that out. So you can get 40% on your debt. You don't exclude lease receivables, and even with the 25%, you're looking at debt and you don't exclude lease receivables. Okay, so no longer excluding lease receivables, and that has come into operation immediately. Yeah, I sort of think maybe they could have, backdated this to the beginning of this tax year, but nonetheless, it has at least come into operation from the time that the bills were tabled in Parliament, but it applies in respect of years of assessment commencing on or after this date. All right, so yeah, it's a little bit unfortunate, I think, for some of the property industry, although I guess the real impact of their doubtful debts will probably be felt more in the next year of assessment, which will be the one that is affected by this amendment. Okay, then for taxpayers who are not using IFRS 9, so there we simply look at how long has the debt been in arrears. If it's been in arrears for more than 60 days, but not more than 120, then you take 25% of the face value. If it's been in arrears for 120 days or more, you take 40% of the face value of the debt. Now here, the point was made that there's inconsistency because taxpayers not using IFRS 9, you take the whole value, the face value of the doubtful debt. But for taxpayers who are using IFRS 9, you have to exclude any secured debt, any security that has been paid. And so they've now decided they need to do this across the board so that we don't have different tax treatment. And so we need to take cognizance of any security that has been given in respect of the debt. So 11J will be amended to ensure that the 25% and 40% here are applied to the debt after deducting any security that is available. And so you see that coming through in the amended wording here. So if the taxpayer is adopting IFRS 9, then your doubtful debt allowance is 40% of so much of any debt due to the taxpayer, if that debt is 120 days or more in arrears, after taking into account the value of any security. 25% of any debt outstanding for 60 days or more, but not more than 120 days. And then again, looking at the face value of the debt, after taking into account the value of any security in respect of that debt. Okay, so basically looking at your unsecured debt. So this amendment coming through, this one has a slightly different date, comes into operation from the 1st of January 2021 and applies in respect of years of assessment commencing on or after that date. Right, so those are the amendments to the doubtful debt allowance, and we'll take a 15-minute break now, and then after the break we'll look at the amendments to the corporate rules. Okay, so I'll see you back at 14:47. Okay, 15 minutes from now. See you just now. Right, welcome back everybody. Hope you are ready to start again. Just carry on sharing my screen. Sorry, I see it has a bit of a mind of its own. There we go. Okay, so sharing the screen, back and ready to start again. Okay, so I'll just switch off the video while I just carry on with the slides, and let's get into the next part of the amendments. And the next part that we're going to be talking about, I see there's no questions that are outstanding. So, okay, so let's get on to the next part. Right, these are amendments to the corporate rules, and there are 3 amendments to the corporate rules. Often we think about the corporate rules just being in section 41 through to 47, but there are some other provisions also dealing with corporate reorganization transactions, one of which is section 40CA, which talks about acquisitions of assets in exchange for shares or debt. And then, of course, section 45 being within part 3, that is your intra-group transactions. And section 46 refers to unbundling transactions. Okay, so the 3 amendments that are coming through now, section 40CA, as I say, currently the title of that section is assets acquired in exchange for shares or debt. And currently it applies where a company acquires assets in exchange for either shares or debt. And what it does is it establishes the base cost of the asset in the company. So where a company acquires an asset in exchange for shares issued by that company, so an asset for share transaction, the company is deemed to have actually incurred an amount of expenditure, so there you get the base cost of the asset, equal to the sum of the market value of the shares immediately after the acquisition, plus any deemed capital gain determined under section 24BA. So there's another provision dealing with corporate restructuring. It's our value mismatch rules. That deals with a situation where there's a mismatch between the true value of the shares that have been issued and the value of the asset that has been acquired. You see, what happens is that if you acquire assets worth, let's say, 10 million Rand, but you issue shares worth only 8 million Rand, you have a situation where you've got your, in terms of section 40CA, you're deemed to have acquired the asset for expenditure equal to the market value of the shares after acquisition, which we said is 8 million Rand. But actually the true value of the assets is 10 million Rand. Now that difference of 2 million, in terms of the section 24BA value mismatch rules, it triggers a deemed capital gain. So that 2 million Rand would have been a deemed capital gain. And so what we do is we then bring that same amount in and add it onto our 8 million. So you end up with the base cost of the asset being 10 million. Okay, anyway, so that's all there. That's not a change that happened this year. That's as a result of changes over the last 2 or 3 years. In part B of section 40CA, it then said where a company acquires an asset in exchange for debt, the company is deemed to have actually incurred an amount of expenditure on the asset equal to the amount of the debt that is issued. But that is the paragraph that in terms of this amendment has now been removed, effective 1st of January 2021 in respect of acquisitions made after that date. So what will happen is that going forward, section 40CA will only apply to assets acquired in exchange for shares, and it will no longer refer to assets acquired in exchange for debt. Now, the reason for this removal is that National Treasury has basically said, you know, we don't need a specific provision dealing with debt. And actually what happened is it did create a little bit of a loophole, because when you have section 40CA, then it means that paragraph 38 of the 8th schedule does not apply. Now, paragraph 38 of the 8th schedule talks about transactions between connected persons that are not at arm's length value. Then we say that when paragraph 38 applies, the disposer is deemed to have disposed of the asset for proceeds equal to the market value of the asset on the date of disposal, and the person acquiring the asset is deemed to have acquired that asset for the same market value. But now section 40CA applies, then paragraph 38 does not apply. So actually what you could end up doing is that you could have a situation where you do an asset for debt transaction, you apply section 40CA, and then you could end up with an artificial value being the base cost of the asset. So they're saying that's just creating a bit of distortion. So they're taking that paragraph out of section 40CA. Okay, so going forward, section 40CA will only apply to assets acquired in exchange for shares. Right, then the amendment to section 45 So what we have at the moment, of course, Section 45 refers to intra-group transactions. So typical situation, if you've got company A and company B, both held by the same holding company, they're all part of the same group of companies. They're all resident companies, part of the same group of companies as defined in Section 41. So we've got, they are both subsidiaries of this holding company, right? So company A sells assets to company B. If you meet all the criteria of the definition of intragroup transaction, then that can be a tax neutral transaction. So you wouldn't have recoupments and capital gain arising in company A. You would simply roll those assets over from company A to company B, and all the identifiers and all the characteristics of the asset, including the base cost, any allowances, etc., would simply roll over to company B. That's the whole point of the intragroup rollover relief in Section 45. But there are some anti-avoidance provisions. And one of them is, if you jump down to the bottom of the slide here, Section 45.4, which talks about a degrouping charge, where a transferee has acquired an asset under an intragroup transaction, so that this in our case would be company B, ceases to form part of the same group of companies within a period of 6 years. Then what happens is that under Section 45.4, if you have this degrouping provision, the degrouping charge gives rise to a sort of a deemed capital gain. Now, okay, so that exists. Now, in 2011, they inserted Section 45.3a, which said that when you've got this intragroup transaction, the company B, the transferee, the one that acquires the asset, if they fund the acquisition by the issue of debt or shares other than equity shares, so we've got company A sells assets to company B, right? They're part of the same group of companies. Company B funds that acquisition by issuing debt or preference shares, let's say. So that those are now held by company A, right? Company A now holds the debt or the preference shares. They sold the assets to company B. So in that circumstance, the base cost of the debt or shares held by company A is deemed to have a value of nil. So the holder of the shares, still part of the same group, have a deemed cost of nil. So the reason why they do that is because then when company A eventually sells that share or debt, they would work out their capital gain taking proceeds on disposal minus the base cost of nil. So the whole amount would be subject to being a capital gain. Okay, but now if Section 45.4 is triggered because the transferee company exits the group within the 6-year period, and it triggers this exit charge, which is effectively this deemed capital gain situation, then you've still got company A sitting with a base cost of nil on the debt or shares that they hold, then, exposed to full capital gains tax going forward. However, there's been a deemed capital gain as a result of the application of Section 45.4. So the concern, as expressed in the explanatory memorandum, is that there's a bit of an anomaly here. You could end up with a kind of a double tax situation. And so they want to avoid the double tax situation. So they've now inserted after, this is going to 45.3a, they then insert 45.3b, and they say, right, when you've ended up with the 45.3a situation, so you've got this transfer, you've got the debt or preference shares with a deemed base cost of nil. And then if Section 45.4 is triggered because we have the transferee company exiting the group, they cease to form part of the same group of companies, then instead of the company A sitting with a base cost of nil, their base cost would kick up basically to what it would have been without the intragroup transaction provision. So if they're holding a debt, it would actually then have a base cost equal to the face value of the debt immediately after the acquisition of the asset, less any repayments that might have been made in the interim. And if they're holding a preference share or anything other than the equity share, then it would be the subscription price at the end of the day that the share was acquired, less any capital repayments that might have been made, any returns of capital in respect of that share. Okay, so it basically just kicks the base cost back up again to what it would have been had the intragroup rollover relief not applied in the first place. But that's where you've had Section 45.4, the degrouping charge having been triggered. Right, so that's a little bit of a technical amendment applying specifically in your intragroup transaction provisions. And the effective date, 1st of January 2021, years of assessment commencing on or after that date. Okay, and then on to the next amendment as far as our corporate rules are concerned, and this deals with your unbundling transactions. Now, again, we've got rollover relief that applies when you have an unbundling transaction, a different type of corporate reorganization transaction. In the case of unbundling, we've got a company which has shareholders, right? So we've got the shareholders, then you've got the company A. Company A holds shares in company B, and it then unbundles. So it transfers those shares in company B up to its shareholders. Now, without the rollover relief, you would have a situation where you've got company A divesting itself of its shares in company B and disposing of those shares to its shareholders. So you would have possibly recoupments, but certainly you would have capital gains tax implications and even dividends tax implications, because that would be a dividend in specie distribution of an asset to the shareholders. So we have Section 46 that provides rollover relief as long as you've met certain criteria. Then those shares can be rolled up to your shareholders, basically in a tax neutral situation. However, again, there are some anti-avoidance provisions, and one of them is Section 46(7). And Section 46(7) says that you will not get the rollover relief if, so you've entered into an unbundling transaction, you've transferred your shares up to your shareholders, but immediately after the transaction, if 20% or more of the shares in the unbundled company, that's the company B shares that have been transferred up, if 20% or more of those shares are held by a disqualified person, either alone or together with any connected persons in relation to that disqualified person. And disqualified person means it's then defined as being a non-resident or government or a PBO or a recreational club or a retirement fund or a tax-exempt entity. So we're saying that you're not going to get the rollover relief if immediately after the unbundling transaction, 20% or more of the shares in this unbundled company, company B, are held by disqualified persons, but then you'd look at each disqualified person together with any connected persons in relation to that disqualified person. Okay, and if that adds up to more than 20% or 20% or more, then you have no rollover relief. So it's an all or nothing situation. Either you get the rollover or you don't get the rollover. So the reason why they do this is because we do this unbundling transaction. We transfer the shares up to the shareholders of company A in a tax neutral fashion. If those shares are now held by a shareholder who is a non-resident, tax exempt, the government, etc., we are not able to tax any subsequent disposal of the shares by that disqualified person. So we've done a tax neutral transfer and now putting our shares in an out of reach tax situation. So we're saying, well, we're happy to do that up to a point, but in terms of this particular provision, not if 20% or more of the shares are held by disqualified persons, but you would only aggregate the shareholdings if you have two or more disqualified persons who are connected persons. So you could have 80% of your shareholders in company A who now hold shares in company B being non-residents, but you wouldn't add all their shareholdings together because they're not connected persons. They're completely unrelated. And so this 20% rule wouldn't apply, even though these shares are now sitting in the hands of non-residents. And so in the explanatory memorandum, they make the point that they are actually sort of eroding our tax base through this. If you pick up the second bullet point, government has noticed the increased use of unbundling transaction provisions to erode the tax base in structures that use the unbundling transactions to distribute shares of unbundled companies tax-free to especially non-resident investors. But you could be transferring them to tax-exempt entities or government, which is tax-exempt as well. Okay, so first of all, what they wanted to do is they wanted to just remove the reference to connected persons. So basically, as long as you've got disqualified persons holding at least 20% of the shares in the unbundled company, company B, you would lose the rollover relief. But then there was some concern that if you just remove this reference to connected persons, you're going to end up with this all or nothing situation, and that is a little unfair. So the recommendation and there's a lot of engagement around this. Apart from this, written submissions that were made, there were then workshops that took place, and the recommendation was that you should rather look at a pro rata situation, decide what you're willing to tolerate in terms of disqualified person ownership of your Company B shares after the unbundling transaction. And they said, right, we can tolerate 5%. And then anything over and above that won't qualify for the rollover relief, but then it will just be those transfers to the disqualified persons that won't qualify for the rollover relief. It won't sort of negate the rollover relief totally. So it's not going to be an all or nothing situation. So what we see is this amendment coming through, where it now says, it will say once this becomes effective, that the unbundling rollover relief does not apply in respect of any equity share that is distributed by an unbundling company, that's my Company A, to any shareholder. So I said Company A is distributing shares in Company B up to its shareholders. So Company A, if it distributes any equity share to a shareholder that is a disqualified person and holds at least 5% of the equity shares, then the rollover relief won't apply to that portion of the overall unbundling transaction. Okay, we're going to talk about unbundling transactions a little bit later on in terms of one of the recent SARS binding general rulings. But just to point out here that when you enter into an unbundling transaction, Company A has to transfer all the shares in Company B. It can't just distribute some. Has to distribute all the shares in Company B up to its shareholders pro rata to their shareholding. So if you end up with disqualified persons holding at least 5% of the equity shares, any particular shareholder that is a disqualified person that holds at least 5% of the equity shares now in the unbundling company, Company A, and they're going to end up with 5% in Company B, then that portion will not qualify for the rollover relief. Okay, but it's not an all or nothing situation. So I think it's a much more fine-tuned approach to what they had in the draft legislation. So this effective date came into effect immediately, basically when the bills were tabled in Parliament on the 28th of October, and applies to any unbundling transactions entered into on or after that date. Right, so far so good. Not seeing any other questions coming through. So let's have a look at loop structures. Let me take a sip of strong coffee before we get onto this one. Right, so when we talk about loop structures, now here, when we talk about a loop structure, let me just explain it very simply as saying a loop structure is in essence where you've got a South African resident who invests in an offshore entity, an offshore company, buys shares in an offshore company. That offshore company invests and buys shares into a South African resident company. So there's your loop. Okay, but it's not back to the same investor. But you might have Joe Bloggs, individual, buying shares in an offshore company. Offshore company invests in SAX Pty Limited. Okay, South African resident company Pty Limited. But it is a loop structure in terms of we've got the capital that's gone out to the foreign company. That foreign company has invested back into South Africa. But the problem, the reason why the Reserve Bank was never keen on these loop structures is that you then end up with a situation where your investor, Joe Bloggs, has taken money out of South Africa to invest into the foreign company. So you've got an expatriation of capital. And then that foreign company being the shareholder of the South African company, so the South African company distributes dividends, they go out of the country as well to that foreign company. So another expatriation of capital. So for many years, these loop structures were prohibited in terms of the exchange control regulations. And then just recently, there was a concession made to say that residents could hold up to 40% in a foreign company. All right, so that was a concession that was made last year, basically saying that you can invest as an exception. Private individuals and South African companies may acquire up to 40% of the equity or voting rights in a foreign company, which may in turn hold investments back into South African companies, but not just South Africa. CMA talks about common monetary area. Okay, so anywhere in the common monetary area. Okay, so currently these are permitted, but only with a shareholding up to 40%. Now, we mentioned earlier that government had announced certain proposals around relaxing exchange controls. And one of the areas where they are looking at relaxing exchange controls is in exactly this area. So we told in the explanatory memorandum that they're going to review these exchange control rules, and they may well allow a greater than 40% shareholding in a offshore company, which could be part of a loop structure. So you could go above 40%. Not yet, don't rush out and do this, but they are looking at relaxing the exchange controls in this regard. And so anticipating the relaxation of the exchange control restriction, they are now looking at making changes to the Income Tax Act to say, okay, when this happens in the future, that you're allowed to hold more than 40% in this loop structure, we already have the tax legislation to make sure that we're not losing part of our tax base as a result of this relaxation. Now, you'll see the amendments are coming through Section 9D, which talks to controlled foreign companies, and paragraph 64B of the 8th schedule, which is a participation exemption that applies when a resident sells shares in a foreign company. Then you would disregard the capital gain or loss on the disposal of shares in that foreign company, as long as you have met certain requirements. And one of the requirements is that you've got to have a resident who is disposing shares in a foreign company, and immediately before the disposal, they held at least 10% of the shares in the foreign company. They held that interest for at least 18 months. They are disposing to a non-resident who is not a connected person. Okay, so there's various requirements that have to be met. If you meet all those requirements, and key to that is this holding of at least 10% that you've held for at least 18 months in the foreign company. If you meet all those requirements, then the resident who's selling the shares in the foreign company would disregard any capital gain or loss on the disposal of the shares in the foreign company. So it's a complete disregarding of the capital gain or loss under paragraph 64B if you meet the criteria. So the changes that are coming through here, first of all, since I'm talking about paragraph 64B, let me just make the point that they're going to limit the exclusion of the capital gain or loss, that it won't be the whole capital gain or loss on the disposal of the shares in the foreign company. They're going to limit that. And in terms of Section 9D, what they're going to do here is they're going to limit the exemption that applies for the dividends that have gone from the South African company to the foreign company. You see, when we talk about Section 9D with controlled foreign companies, especially in terms of Section 9D2A, which is the amendment in this particular set of changes, Section 9D2A talks about determining the net income of the controlled foreign company. So first of all, a controlled foreign company is a foreign company of which more than 50% of the shares are held collectively by South African residents. So, I mean, currently you're talking about a 40% limit, but if that goes above, if it goes up, then potentially you could have more than 50% of the shares in the foreign company held by residents. Then what happens if none of the exemptions or exclusions applies? Then you have to then do this determination of net income of the CFC, the controlled foreign company. And to do that, you have to say, right, if this foreign company was a resident, what would its taxable income have been? Do that calculation, work out this thing called net income, being this equivalent of what the South African taxable income would have been. And then for all the South African resident shareholders, they have to include part of their net income in their taxable income in each year of assessment relative to their shareholding. So if they hold let's say 8% of the shares, then they have to include 8% of the net income. I'm putting it very simply here, but that's how this net income situation works. So if you were doing this determination of net income for a foreign company, okay, it's a CFC, and you're now applying Section 9D2A. And this foreign company is receiving dividends from its South African subsidiary. So those dividends would come into gross income, and they would then be exempt under Section 10(1)K. So they'd be fully exempt. So it wouldn't give rise to any net income. However, what they are saying here is that if it's a non-resident company in a loop structure, then we shouldn't give a full exemption for those dividends. Just like with the participation exemption on capital gains tax, they're saying we shouldn't give the full exclusion of capital gains. So there were submissions around this saying, well, you know, you're saying that we're not going to give the full exemption on dividends on the basis that those dividends, you know, should be taxed. But the dividends have been taxed to some extent in terms of dividends tax. SA company pays a dividend to a non-resident. There's going to be a certain amount of dividends tax payable, usually, okay? Maybe not the full 20%. It might be a lower rate as a result of the application of a DTA. But usually only comes down as far as 5%. Of course, we saw in terms of recent case law going through the European Courts of Justice and so on, that sometimes it could be as low as 0%, but be that as it may, it can be something less than 20%. And so they've said, right, we will take consideration of the fact that it might be less than 20%, but we still don't think that you should get a full exemption on the dividends as far as income tax is concerned. So they're putting in this rather lengthy amendment here. So what they're doing in section 9D2A, when we work out the net income of the CFC, so remember that we're saying if that foreign company was a resident, what would the taxable income look like? So you'd be bringing your South African dividends into gross income, and you'd be looking at the 10(1)K exemption, right? But now this proviso says any 10(1)K exemption will not apply in respect of the portion of the dividends received by or accrued to a CFC determined according to this formula. So you're then going to say, right, I would normally get my full exemption, but now I'm not going to get an exemption up to the amount determined under this formula. And basically starting with 20 over 28 times by the amount of the dividend, but then taking into account, and this is D over here, that there will be a certain reduction depending on how much dividends tax was paid. If you paid full dividends tax, and basically this is talking about dividends tax paid by the controlled foreign company, all right? So if you paid full dividends tax of 20%, then there'll be no disregarding of the exemption. You'll get the full exemption. But if you only paid some dividends tax going down to 5%, then you're going to basically say C is the amount of the dividends, D is minus, if you paid dividends tax of 5%, minus 25% of that, so you're now to 75% of your dividend, multiplied by 20 over 28, that's the amount that will be disregarded. Okay, so it is a fairly complex situation. I'm not going to dwell on it too much because I know it has fairly limited application, but just so that you have a kind of a high level idea that there is going to be a disallowance of some of the exemption for your South African dividends, but the amount of the disallowance is linked to how much dividends tax was paid to try and compensate for the fact that if you paid full dividends tax, then we will allow the full amount of the income tax exemption. So this comes into effect from the 1st of January next year and applies in respect of dividends received by or accrued to any CFC on or after that date. And then as far as your participation exemption under paragraph 64 is concerned, so remember I said that currently, if you qualify, you disregard the entire capital gain or loss on disposal of the foreign shares, but then they are going to say that in the case of a foreign company that is a CFC, all right, this disregarding will not apply in respect of any capital gain or loss determined in respect of the disposal of any share in a CFC, to the extent that the value of the assets of the CFC are attributable to assets situated in the Republic. So in my example, if I had an individual shares in this foreign company, CFC holding shares in a South African company, if these shares in the South African company make up 80% of the value of that foreign company, the South African resident sells the shares in the foreign company, they meet all the requirements for the paragraph 64B exclusion, but then you would only be able to exclude 20% of the capital gain. You would not exclude the capital gain that relates to the shares in the South African company. Okay, so that's the amendment that comes through there, limiting the amount of the participation exemption when it relates to shares in a controlled foreign company. Right, and then, okay, so that's basically our amendments around loop structures. There's also another amendment sort of with a bit of an international tax flavor, if you like, and that's this one, paragraph 82 of the 8th schedule. Currently, there's just one paragraph 82 of the 8th schedule, and what they're doing is they're actually splitting this now into 2 separate paragraphs. So they're just disaggregating it. At the moment, if you have a look at paragraph 82, it talks about a trust that determines a capital gain, or a trust, if it were not a resident, would have determined a capital gain. So one paragraph talks about a trust being a resident and a non-resident. Now they're splitting this out. And paragraph 2, if you have a look, I know I've put all the wording on here, which is maybe a little bit too much, but so the revised version of 80, subparagraph 2, talks about a trust determining a capital gain in respect to disposal of an asset in a year that a resident beneficiary acquires a vested right to that capital gain, and then basically saying you disregard the capital gain in the hands of the trust and take it into account in the hands of the beneficiary. Then, as far as non-resident trusts are concerned, they have then split that out into a separate paragraph 82A. Okay, and there, so here you see where a beneficiary who is a resident derives an amount through vesting from a trust that is not a resident. And that amount was derived directly or indirectly from that trust to another trust that's not a resident in respect of the disposal of an asset, and that amount would have constituted the capital gain had the trust been a resident. Okay, so 82A talks about your non-resident trusts now, and it's just been split out. So this is the explanatory memorandum basically makes the point that they seek to deal separately with a capital gain derived by a resident and a non-resident trust, which is vested in a resident beneficiary during the same year of assessment. Okay, so I don't think we need to dwell on that one too much. Okay, then on to some of the VAT amendments. So just running through these VAT amendments fairly quickly. Definition of enterprise. Remember that in the VAT Act, if you have basically a vendor who is carrying on an enterprise in the Republic, then in terms of Section 7, they need to be charging VAT on any of their taxable supplies. Okay, so carrying on an enterprise is key to whether you are actually liable for VAT as a vendor or not. So we've got a definition of enterprise in Section 1, and of course it runs and has been expanded recently with your online services and so on. But basically it talks about any enterprise or activity carried on continuously or regularly by any person in the Republic. So it's quite broad. And then it goes on to include and exclude certain things. And what they're doing here, right down at the end, they've got subparagraph 13, which is excluding. Okay, so it's a proviso that says where a person is neither a resident nor a registered vendor, they supply the use or right of use of ships, aircraft, and rolling stock under a rental agreement, that activity is deemed not to be the carrying on of an enterprise, notwithstanding that the goods are supplied for use of the Republic. As long as the supply is made to a recipient that is a resident, the goods are supplied for use by the resident in the Republic, and basically the resident user would declare those goods for customs and excise. So we're taking that out of the definition of enterprise. This used to have a specific ruling applying to it, but then following the amendment to Section 72 and rulings being withdrawn, they have deemed it fit to rather bring this into the body of the VAT Act. So it has very specific application: ships, aircraft, rolling stock under a rental agreement from a foreigner who's not a registered vendor used in the Republic, etc. So that basically saying it's not an enterprise, it won't attract VAT, but the person using the goods would have to declare the goods for customs and excise and would have to pay the import taxes. And then on corporate reorganization, we spoke about Section 45 and Section 46 earlier. Of course, in terms of the VAT Act, we do have Section 825, which is our kind of equivalent of the corporate rules for VAT purposes, but it does apply in very specific circumstances. And basically, as told in the explanatory memorandum, the income tax rollover provisions will not apply to the transfer of certain assets. So, for example, if you have, in fact, they give you an example here. If you have company A selling assets to company B, it's selling a whole lot of assets under going concern disposal. You have to go through this on an asset-by-asset basis when you're looking at Section 45 of the Income Tax Act. And then you have to identify for each particular asset, does the rollover provision apply? It will not apply if, for example, you have a different use. It's used as trading stock in the seller, but the buyer is going to use it as a capital asset or vice versa. Also, it won't apply if your market value is less than the base cost of the asset. So in other words, it would result in a loss situation. Then the rollover relief will not apply. So it happens in a Section 45 transaction where you are disposing of a going concern, that some assets qualify for the rollover relief and some do not. Okay, but the VAT relief provisions under Section 825 also then don't apply. And so it means that those assets are then subject to VAT at the standard rate. And they don't on their own constitute the transfer of a going concern. So you're not going to get the rollover relief. And you could also, you can't get the zero rating provisions under Section 11(1)(e), because that's excluded when the transaction basically falls outside of Section 825. So we have this situation where some of the assets might then attract VAT, which then makes this whole thing a bit problematic. And so the idea is we want to rather zero rate the whole provision. And so to address that, they're going to amend Section 825 to allow vendors to elect that they elect out of Section 825 and then rather use the zero rating provision of Section 11(1)(e), so that the whole transfer would be zero rated. And then effectively, you're getting the same thing, but 825, basically there's no supply. It's just that the buyer steps into the shoes of the seller. Whereas under Section 11(1)(e), there is a supply. It's a taxable supply, but it's taxed at the zero rate. Okay, so there's still no VAT payable, but it's just much cleaner than having VAT on some of the assets, but not all of the assets. Okay, so they've then added on this extra proviso saying Section 825 will not apply. When you talk about Section 42 asset for share transaction or Section 45 intra-group transaction, where the supplier and recipient have agreed in writing that they're going to opt for Section 11(1)(e). And then on irrecoverable debts, so when you've claimed an input tax credit, and then either you cease to be a vendor or the vendor goes insolvent and there's a deemed supply, you've got to raise output tax. But the question is, what tax fraction do you use to raise that output tax? And they're just clarifying here that you use the same tax fraction that was used when you claimed the input tax. So if you claimed the input tax when the VAT rate was 14, then you're going to use that same tax fraction of 14 over 114 when you work out the output tax on the deemed supply. Okay, then on to our tax administration amendments. Section 95 of the Tax Administration Act. Let me just have a quick look to see if there's any questions. Sorry. Okay. Not really. Okay, not seeing any questions there. So let's carry on. Yeah, tax administration, right. This is from the Tax Administration Laws Amendment Bill of 2020. Right, so the First Amendment looks at estimated assessments. Now, when can SARS raise an estimated assessment? So we see in Section 95 of the TAA that currently there are two circumstances where SARS can raise an estimated assessment: where the taxpayer does not file a return, or where the taxpayer submits a return or information that is incorrect or inadequate. And notice that if you have a situation where a taxpayer has not filed a return, and SARS raises an estimated assessment, that assessment may not be disputed until the required return is filed, and only if SARS has failed to revise the assessment in light of the filed return. And SARS makes the point that this enables them to check that all the facts are available when the assessment is revisited, and dispute resolution timelines that would otherwise apply may be relaxed. Okay, but the point of the matter is that SARS can raise estimated assessments in these two circumstances. Now, they have mentioned in the explanatory memorandum that they want to add a third circumstance. They go into a whole long story here, which we don't necessarily have to have a look at. But what is important is that they're also transferring certain of the provisions from Section 91, which talks about assessments, through to Section 95. So anything dealing with estimated assessments will now sit in Section 95. And as part of that, they also want to, if you jump down to this fourth bullet point over here, the time period within which a taxpayer may request SARS to revise the estimated assessment. Basically, it used to be limited to 30 business days. but now it has been extended to 40 business days. All right, so these are all changes that are coming through in the revised version of Section 95. So here's the revised version. First of all, they've added in this third category of when SARS can raise an estimated assessment is when the taxpayer does not submit a response to a request for relevant material under Section 46 after delivery of more than one request. So there has to be a request and a reminder. If the taxpayer still fails to provide the relevant material, this is not a tax return, it's the supporting material, then SARS can raise an estimated assessment. Okay, then subparagraph 2, unchanged, SARS must make the estimate based on information available. Subparagraph 3, exactly as was there already. If the taxpayer is unable to submit an accurate return, a senior SARS official can agree in writing as to the amount of tax chargeable and then issue an assessment accordingly. That's then what we call an agreed assessment, and it's not subject to objection and appeal. And then coming in and being brought in from Section 91, all right, the making of an assessment under 95. So the estimated assessment does not detract from the obligation to submit a return or the relevant material. So you still got to submit the return, even though SARS has raised an estimated assessment. And this estimated assessment is not subject to objection and appeal unless the taxpayer actually submits the outstanding return or the relevant material as required. And then only if SARS has not issued a reduced or additional assessment. Okay. So what would normally happen, they raise the estimate, you submit the outstanding material, they then revise the estimate and off you go. But if SARS doesn't issue the reduced or additional assessment after the additional information is provided, then it is subject to objection and appeal. So it's not subject to objection and appeal unless SARS has failed to reduce the additional, failed to amend the original assessment, the estimated assessment. And then coming in from Section 91 as well, the taxpayer in relation to whom the estimated assessment has been issued has 40 business days from the date of the assessment to request SARS to issue the reduced assessment by providing the full return or the outstanding material. A senior SARS official can extend that period for a period not exceeding the relevant period in Section 99, which is your 3 or 5 year prescription period. Okay, so they can extend up to that point. Okay, so linked to that also, because we've just said here that you would request SARS to issue a reduced assessment once you submit the full and true return, then linking through to that, we've seen an amendment in Section 93, which talks about reduced assessments, considering exactly the circumstance where the taxpayer has requested SARS to issue a reduced assessment under Section 95. Remember, all of these administrative amendments are typically always effective from the date of promulgation of this Taxation Laws, Tax Administration Laws Amendment Act. All right, then the next change is on interest on overpayment. So if a taxpayer overpays on their provision, on their tax assessment, they overpay for whatever reason, then SARS has to pay a refund, and it should carry interest. In terms of Section 187(3)(h), they are going to put in this additional paragraph that says that the interest won't kick in. You'll only start calculating the interest 30 days, and that's 30 business days after the date that the payment has been made. So there's a delay, all right, before the interest starts accumulating. And the reason for the delay, SARS says they need time to check whether it really is an erroneous payment, look at the nature of the payment, etc. And so they need 30 days to do that. Originally, it was going to be longer than that. They have actually shortened that back to 30 days as a result of the submission process. Then on to refunds, and a few more situations where SARS can withhold refunds. It seems to be also a perennial favorite to add onto the list where refunds can be delayed. So here, where there is a pending criminal investigation, any refund can be delayed until that is finalized. However, you'll see in Section 193 that there is a possibility for a senior SARS official to negotiate for security to be paid. And if the taxpayer pays the requisite security, then the refund can be paid out. Refunds will also be withheld going forward if there are any outstanding STL or UIF returns. So we see these amendments coming into the Skills Development Levies Act and the Unemployment Insurance Contributions Act, basically saying that if there's any outstanding returns, then SARS can refuse to authorize a refund under Section 190 of the Tax Administration Act. So that refers to any overpayment of tax that needs to be refunded. The refund will be blocked if there are outstanding SDL and UIF returns. Then a very contentious amendment, this whole issue around statutory offences. And this links to three particular provisions in the tax legislation, which list statutory offences. Paragraph 30 of the 4th schedule, dealing with statutory offences linked to employees' tax and provisional tax. Section 58 of the VAT Act, and then the overarching statutory offence list in the Tax Administration Act. Now, in all three of these cases, if you look at the list of possible statutory offences or criminal offences, it starts off with any person who willfully and without just cause, and then it goes on to list all these different offences that could be committed. And so the issue is the person must have committed these offences willfully and without just cause. So initially in the draft amendments, what SARS wanted to do was just delete these words willfully and just say a person who without just cause commits one of these offences. So this kind of deliberate intent was going to be taken out. There was a huge amount of controversy around this, a lot of discussion around statutory rights, around the constitutional rights of the taxpayer and so on. And SARS said, okay, they will make certain concessions. There were a lot of concerns around the fact that if you simply remove those words, it means that a person who has negligently failed to meet some of the obligations under the legislation could be guilty of criminal offence and could actually land the person in jail. So at the end of the day, SARS then went back and re-looked at this, and they then came up with a different solution. And what they've done now is that they've basically taken each of these statutory offence provisions and they've split it into two. The first part looks at a person who willfully has committed certain offences. Notice they've kept that word willfully. In fact, they've taken out without just cause. They've just kept willfully. And then the second part talks about willfully or negligently, meaning that they are specifically saying that, yes, negligence can give rise to criminal prosecution. So let's look at the 4th schedule, dealing with employees' tax and provisional tax. So what we have now, these two parts. So first of all, it says a person who willfully uses or applies any amount deducted by way of employees' tax for purposes other than paying the amount to the commissioner. So if you willfully use that money for any purpose other than paying it back to SARS, that could give rise to a criminal offence. Also note paragraph 32, which says that unless you can prove a reasonable possibility that the amount was not so used, they would be regarded as basically having used the amount for purposes other than paying it to the commissioner. All right, so be careful of that employees' tax withheld and then used for other purposes not being paid over to the commissioner can give rise to criminal prosecution. Then the second one, if you are not an employer and you have no authorization to issue employees' tax certificates, but you go ahead and issue employees' tax certificates. Notice here it says willfully issues or causes to be issued any document purporting to be an employee's tax certificate. So again, willfully doing that. So in either of those two cases, the person, if they're found guilty, they would be liable upon conviction to a fine or to imprisonment for a period up to 2 years. Previously, paragraph 30 spoke about 12 months imprisonment. Now it goes up to 2 years. And then in the second one, talking about willfully or negligently. So this is new now. We never used to talk about or negligently, but now this is coming in. So willfully or negligently failing to deliver employees' tax certificates to employees, willfully or negligently failing to notify the commissioner of having ceased to be an employer if you were registered as one, or willfully or negligently failing to submit, if you're a provisional taxpayer, your estimate of taxable income as required under paragraph 19, which is both your first and second estimates. Willfully or negligently failing to submit an estimate of taxable income could give rise to a criminal offence, and on conviction, a fine or imprisonment up to 2 years. So they're not playing around here. And I think it's really important to bear in mind that, you know, this really raises the hurdle quite substantially, and basically saying that yes, you could be liable for criminal conviction for negligently failing to meet some of your obligations. We see similarly in the VAT Act, we talk about offences committed willfully, and then offences committed willfully or negligently. And if we go to the general criminal offence provision of section 234 of the Tax Administration Act, again, part 1 talks about any person who willfully commits certain things: submitting a false certificate, erroneous information, failing to reply to queries, obstructing SARS officials, refusing to give assistance, holding themselves out as a SARS official, dissipating a person's assets. So if that's committed willfully, then if they're guilty, on conviction, they would be liable to a fine or imprisonment up to 2 years. And then the willful or negligent aspect comes in terms of subparagraph 2. Any person who willfully or negligently fails to register or notify SARS of a change in personal details, registered details, fails to appoint a representative taxpayer, fails to register as a tax practitioner, fails to submit a return or document to SARS as required, fails to retain records, the 5-year record retention period, fails to produce any information requested under section 46, all right, willfully or negligently, and it goes on, fails to attend or give evidence, fails to comply with a directive, that's where you've been appointed as an agent and you fail to comply with the instruction to withhold tax, fails to disclose any material fact, etc. Okay, so you get the point here, that a person who is negligent and then fails to comply with any of these requirements could end up with criminal prosecution. And again, could be a fine or imprisonment for a period not exceeding 2 years. I think there's still going to be quite a lot of activity in this area, because it's going to be interesting to see when this actually comes before the courts to consider whether this is actually constitutionally valid and how SARS actually applies this provision. So remember that this is going to be effective from the date of promulgation. Right. Just quickly on the Disaster Management Tax Relief Act, I just want to talk quickly about the deferral relief for employees and provisional tax, and then the deduction for donations. So in terms of the deferral relief, remember we had the deferral relief for employees tax and provisional tax. Really important to bear in mind that you only were eligible for the deferral relief if you were a qualifying taxpayer as defined. That means you were a company, trust, or individual. In the case of PAY, also could consider a partnership that is a taxpayer carrying on a trade, gross income not exceeding 100 million for the year of assessment ending between April and March 2021. Gross income, and this is really important in terms of the mix of gross income, especially for your provisional taxpayers who might be earning remuneration. So your investment income, interest, dividends, foreign dividends, royalties, rental, annuities, and also your remuneration together may not comprise more than 20% of your total gross income. So even if the person's gross income is only 1 million rand for the year, they can't get more than 20% of that gross income in the form of this investment income or remuneration. If it is so, then they don't qualify for the deferral relief. Okay. In the case of rental companies or people who are in the rental business, if their main business is the letting of property, then that's not regarded as investment income, it's regarded as trade income, then that's fine. That's not going to prevent you from being a qualifying taxpayer. And then finally, the person must have been tax compliant at the time that they were using the deferral relief. Okay, so the way that it worked, the employees' tax payments, remember that you only had to pay 65% across, and the balance of 35% was then repaid in 6 monthly installments. In terms of the Tax Disaster Management Act, that period was extended. So instead of going through to the end of August, it went through to September, so that should actually be September, and then your repayments went from October through to March 2021. All right, so bearing in mind that if you have to repay over those 6 equal monthly installments, it's critically important that you do pay the deferred amount back on the due date of each of those months. Otherwise, you end up being non-compliant, and then basically you're no longer eligible for any of the deferral relief, and you could end up with late payment penalties and interest. In terms of the provisional tax payment, again, qualifying taxpayer. So you had your deferral on the first provisional that fell between April and September 2020. So instead of paying half of your tax for the year, you only have to pay 15%. So you take total estimated taxable income, work out the tax on that, times by 15% minus employees' tax paid and any 6-quart rebate that you might be entitled to. Employees' tax shouldn't be a big feature here, because remember that in order to be a qualifying taxpayer, you would not have been allowed to earn more than 20% of your gross income by way of investment income and remuneration. So employees' tax should not be a big feature here. Okay, but nonetheless, take your total taxable income times 15%, then take off what tax you've actually paid. The balance becomes payable for the first provisional. And then the second provisional falling up until the end of March next year. Then basically you then say, right, when you do your second provisional on the last day of the year of assessment, what is my estimated taxable income at that stage? Work out your normal tax per tables, etc., minus your rebates. And then you take 65% of that total, minus what you've paid as a first provisional and minus any employees tax and 6-quart rebate that you might be entitled to. Okay, so that'll come through with your second provisional payment. So by the time you do the second provisional payment, if you're dealing with a qualifying taxpayer, you would have paid 65% essentially of the total provisional tax that you would otherwise have paid by the last day of the year of assessment. And the other 35% is payable by the effective date, which is 6 or 7 months after year end. So if you're dealing with a February year end, add on 7 months, end of September, you must pay that other 35% by the end of September. If you've got a March year end, add on 6 months, also end of September. Okay, so you must pay that by the effective date. Otherwise, you're going to end up with late payment penalties and so on. And of course, according to the normal provisional tax rules, whatever provisional tax is still outstanding after the effective date will be subject to your Section 89 quat interest. In terms of your donations to your COVID-19 funds, so these donations, there was a concession made because obviously, you know, it takes quite some time to get a fund approved as a PBO under Section 30 and then also for the purposes of Section 18A. So the concession was made that any donations made, whether it be cash or property in kind, to a COVID-19 disaster relief organization, and there's a definition of that in the Act, as long as your donations were made between April and September 2020, that they will qualify for deduction under Section 18A. And that will obviously be, if you're looking at individuals, February 2021 year of assessment. If it's a company with a September year end, it'll be the September 2020, etc. Okay. Now, in terms of the normal Section 18A rules, your deduction is limited to 10% of taxable income before this deduction. And then normally what would happen if there's any excess, you would carry it forward. If in this situation, let's say that you've got taxable income of 10 million Rand and you've made various donations and you've also made a big donation to the Solidarity Fund. So in total, your total donations amount to 1.5 million. So normally you'd be limited to 10% of 10 million, 1 million Rand. But if that excess is due to a donation to the Solidarity Fund, then you can deduct up to an extra 10% of taxable income for your Solidarity Fund donation. So then you could potentially deduct the whole 1.5 million if that excess is due to a donation to the Solidarity Fund. If it turns out that maybe you had donated 3 million Rand to the Solidarity Fund, but now you can only deduct effectively 2 million, 20% basically, I'm simplifying this, but say 20% of your taxable income, 2 million. So that extra 1 million to the Solidarity Fund, you would not be able to carry that forward. So any amount deducted under this additional limit can't be carried forward under the proviso of Section 18A. Okay, and that really brings us to the end of our presentation for today. So as I promised that I would leave a few minutes at the end for Q&A. So if you have any questions, now is the time to send them through. I'm seeing an empty Q&A box and I'm not seeing anything in the chat box. Everyone's gone terribly quiet. I hope that you're all still there. If you have any questions, yeah, please do just pop those through. Okay, here's one. SA is facing an increase in the budget deficit amplified by a reduction of tax revenue due to the economic impact of COVID. What are the anticipated tax mechanisms or solutions to address the tax revenue reductions? This is a scary question, because it does seem that the government is hard pressed. They've got few options to deal with. So increases in tax, the income tax rates, especially for individuals, do seem to be likely. I don't want to spread alarm here, but I mean, I'm not the only one saying this. It seems to be a general thing. In fact, even the minister alluded to this in his medium-term budget speech, that we might need to tighten our belts. I don't know if there's anything left, so increases in tax possible. I mean, increases in VAT, always a very politically charged thing. And we saw that the fallout the last time they increased VAT. I'm not sure they're going to do that again. I think many commentators have said government is scared off that one now. Carbon tax raises very little tax. And wealth tax, I know, it sounds good as a political argument, but wealth tax is going to raise very, very little tax. So really, the alternatives have to be to manage government spending more carefully. That if government spending is managed more carefully and you can achieve savings in government spending, then you would reduce your fiscal deficit. And I think this is what the World Bank, IMF, etc. are saying, is that they don't want to lend more money unless there's some undertaking by government around managing government spending. Much easier to, well, I say this, I mean, yeah, it should be much easier to save a few billion rand through savings on government spending than try and raise a few extra billion rand through tax revenues. I think that it's just the options, the upside on tax revenue is extremely limited, but it's not to say that they won't try. And so I do think it's quite possible that we might see increases in personal income tax next year, unfortunately. All right, so that's my take on it. Don't attach any significance to that. It's just my informal response. Okay, then, is there any authority in case law legislation for the application of business days by SARS where the legislation explicitly reads days? Yeah, now, in the Tax Administration Act, it is specifically defined that when it talks about days, it means business days. And then, of course, business days is also defined as meaning days other than Saturday, Sunday, public holiday. All right, so that's very clear in the Tax Administration Act that when they talk about days, they mean business days. In fact, it is clarified also in the various regulations that go along with that. So in other cases, you're looking at the Interpretation Act, and there it means you go back to the normal meaning of the word. So if you just say days, outside of the Tax Administration Act, it could be construed as calendar days. All right, whereas if you want to say business days, you should actually say business days. All right, so the short answer is when it deals with tax administration, day means a business day. In other contexts, day would mean a calendar day. I hope that helps you. All right. Okay. So thanks very much, everybody. Thanks very much for joining me. It's been great to connect with you again. And can you believe we're already at the end of 2020? And we have survived. And hopefully we're not going to have too much backlash. I'm actually, can you believe it, flying to Port Elizabeth tomorrow, right into the COVID hotspot. So yeah, not really the greatest place to be right now. Hopefully we don't see that spreading through the rest of South Africa. Hopefully you can all have a good, peaceful break in December and hopefully even into a little bit of January. And I wish you all the best over the holiday season, over the Christmas season for those who celebrate Christmas. And thanks all for being with us. And yeah, all the best to all of you, and hope to chat to you again in the early part of next year. Goodbye.
And thank you, Jackie. Thanks for your time and thanks for all the information, which is always appreciated. And to echo your words, yes, everybody over the festive season, have a peaceful festive season, healthy, virus-free, yourselves and your computers, and should come back in the new year refreshed. Just on a bit of housekeeping, your certificates will be ready for delivery once all the formalities have been concluded. So stand by for that. There will be a recording available in the next day or so, and copies of notes if you didn't receive them, but I'm sure most of you have. And so thank you Thank you, Danny, and especially thank you, Professor Jackie, and good luck with your new venture into
Thanks very much.
Consulting and
yes.
I suppose a kind of a semi-retirement.
Oh, I don't think quite the semi-retirement just yet, but yes, I will be based in Joburg and doing some consulting and training and all that sort of thing. Yeah. So thanks very much. Yeah.
Okay, thank you, and
thanks
good luck.
For being with us. Yeah.
Good luck, everybody.
Okay.
Thank
you.
Good evening.
Thanks.
Cheers.
Bye. Cheerio.